welcome to KSW Lawyers annual winter business seminar. It's a real pleasure to have everyone here. We've got a full house this morning, so really excited to host you here at this wonderful facility. This is our sixth annual winter seminar, and so it's starting to become a real institution event for us, and we really enjoy gathering together with everyone and sharing knowledge, and we really want this to be an interactive experience today. So we've got lots of great content, lots of different topics, and this is the first year that we've made this a full day program because there's just so much stuff to go over and so many changes to talk about. We didn't want to be limiting ourselves anymore, so that was based on feedback we received, and really happy to be able to give an extended program today. So I'll start with a little bit of housekeeping. So just some rules. Obviously we're lawyers, so there's going to be a disclaimer. Our presentation today is not legal advice, even though we're going to talk about a lot of legal stuff. Obviously, if you have a particular issue, you can come talk to us as you normally would. There's no such thing as a stupid question, so we're going to have lots of time today for Q&A. If you have a burning question come up as someone's presenting, put your hand up and we'll deal with it. But we're also going to have some time reserved just before the lunch break and then in the afternoon as well for Q&A. Please keep the materials confidential. If you'd like to share them, let us know and we can make copies for other people. And make sure you review all the resources we provide, whether that's labor board stuff or WorkSafe stuff. That's for you guys to review. Okay, so today's agenda, we've done the registration and seating. I'm going to start with talking about WorkSafe BC and some updates. And then we'll have a short break, and then Mike Weiler, who's on to my left here, he will give an update on union and labor law issues relevant for union and non-union workplaces.
I'm rarely on your left.
And then Fiona, who's sitting right next to me, will give an update on HR practices and policy updates. We'll then have 15 minutes for morning session Q&A. And then we'll have a 30-minute lunch break. For the afternoon program, Jensen Leung will talk about terminations and just cause. And sorry, after Fiona, Bonnie Louise is going to give us a short presentation related to investigations. And then after Jensen, Rowan and Courtney will talk about human rights updates. We'll then have a coffee break. And then our new immigration lawyer, Annika Hammett, will talk a little bit about temporary foreign workers and immigration compliance issues. And then we'll conclude with a fun one, Tales from the Trenches, by Sandy and Darren. And then we'll have some final questions, and then you're welcome to join us for some more networking at the restaurant downstairs. Okay. So my agenda, I'm going to give a little bit of an introduction on WorkSafe. I'll talk about Bill 41, which I presented on last year. I will go over some mental disorder claim topics. I'll talk about reviews and appeals, and then prohibited action, and then finally some things to look out for on the WorkSafe front. So, as I said last year, understanding employer obligations under the Workers' Compensation Act remains very important for businesses. We're continuing to field many employer inquiries about WorkSafe matters, more so than we did in the past. The past 3 years, I've had lots of updates on legislative changes with WorkSafe. So last year we had the whole Bill 41, the flush toilet requirements, the new first aid requirements. 2025 was actually a slow year for legislative changes. which was nice because there have been so many changes in the last 5 years to WorkSafe. So we're kind of easing into this new regime of duty to cooperate, duty to accommodate. And fortunately, there was nothing new that came at us, despite the fact that there's many other changes that I think this government wants to make. And I talked last year about this Patterson report, which recommended 100 changes. They've done about 75% of them. And so there's another 25%, which may come. But I think the government today is a little bit more focused on the economy. And so there's a bit of a pause on WorkSafe changes, which is good. KSW is an active participant in the Employers Forum, which is an employers organization that advocates for employers on WorkSafe issues. And so they're very well connected with the people high up in WorkSafe. They send out a weekly newsletter. And so we stay up to date on everything that's going on there. And we kind of get that insider access to know what's coming and be able to provide feedback from the business community on changes or things that simply aren't working with the compensation system. So as far as how is WorkSafe doing, it's doing pretty well. There's going to be a $750 million surplus projected for next year. And that's a result of higher than expected investment returns. So they had about a 12% investment return on the billions of dollars in the accident fund that gets invested. And as a result of that, WorkSafe has been able to keep the average base premium rate fairly consistent. So it hasn't increased in the last 10 years. So for 2026, it's anticipated it's going to stay the same, an average of $1.55 per $100 of assessable payroll. That doesn't mean the costs aren't going up. So the 2024 claims costs were $3.2 billion, and that's up from $2.9 billion in 2023. So the claims costs are increasing substantially because of all of these new benefits that have come in, and because of things like mental health claims that are increasing, which I'll talk about. But the investments are doing so well that it's kind of keeping up with the increased costs. And so for that reason alone, we aren't seeing premium increases, which is good, but obviously that's not something that you can bank on. And just a quick note, starting next year, all reporting is going to be digital. I think there was still an option to do it with paper, and that's going to be transitioned 100% to online. So Bill 41, it came out in 2023 and it became effective January 1st, 2024. This is the new duty to cooperate and duty to maintain employment. Just a quick refresher, duty to cooperate means the worker and the employer, if there's an injury, they've got to communicate as soon as practicable, work together to identify suitable work and try to get that worker back as soon as possible. If either is not cooperating, then WorkSafe has the power to intervene and make a decision. And so they can either cut the worker off their benefits if they're not cooperating, or they can fine the employer if the employer is not cooperating. Second of all, there was the duty to maintain employment, which is effectively the duty to accommodate. So this only applies for businesses that have 20 or more workers regularly employed, and it only applies to workers that have been employed for 12 months or more. So if those criteria are met, then the employer must ensure the worker has a job to come back to after a WCB injury. And you've got to put the worker in either the same position or a comparable position if they can come back without restrictions. If they have restrictions, then you have a duty to accommodate them up to the point of undue hardship. So it's very similar to a human rights obligation, but it's just WorkSafe that's enforcing it. And then there's this presumption that if someone does come back from WorkSafe and they're terminated within 6 months of the return, it's presumed that you're retaliating against them for the claim, and you're going to be in breach of your duty to maintain employment. So it's a rebuttable presumption. It's not, 100% liable, but you're facing an uphill battle there. So WorkSafe can issue fines for non-compliance with these duties. The way that they do it is basically, if the employer is not compliant, then WorkSafe is going to be paying the worker, likely. For example, if WorkSafe thinks that there's a suitable position and the employer is not complying with that, the worker is going to keep getting paid by WorkSafe. And the way that WorkSafe is doing the fines is they're saying, well, we're going to make the employer pay that cost. So whatever we pay the worker while you're not complying, effectively, we're going to claw that back from the employer. Similarly, with the duty to maintain, if WorkSafe thinks you can accommodate the worker, as long as you're not in compliance, according to them, your fine is kind of ongoing. And those fines cap at the maximum wage rate for the year, which is about $112,000. So, it's potentially a really punitive measure, but what I've been seeing, and I'd be interested to hear from you guys, it seems that there's a lot more bark than bite with this. WorkSafe seems to really be focusing on compliance and education rather than doling out fines for people. So the experiences I've had, if there is a contemplation that someone's going to be fined or that someone might be in breach, WorkSafe will send a letter with kind of reasoning as to why they think someone's going to be in breach, and the employer will have a chance to explain the rationale for the decision, and then it'll go to a decision on whether there's going to be a fine. So it seems that WorkSafe isn't being too aggressive on that yet, which is nice. And I haven't seen yet any noteworthy decisions from WCAT or the courts on this. And so it may be another year or two before we start getting a little more guidance on that.
Chris, can I just say something? I just want to point out that Chris is our absolute expert in WorkSafe, and which has been great for me because I don't have to do that stuff. But one of the things that I know Chris does is maintain that relationship with the key people at WorkSafe, just like maintaining a good relationship with people at the Labor Board, the Human Rights Tribunal. It gives you a better segue into working out a deal and avoiding a big fight. So that's important.
Thanks, Mike. So I've just put 3 kind of real life examples that we've dealt with in the last year where Bill 41's been applied. So one of them was, there was a worker, he had injured his back at work in 2022, gone on a WorkSafe claim, come back to work with some restrictions, but able to work. The worker then had an aggravation of the injury in 2025, and so the claim got reopened, and he went back off to do some additional treatment. So the claim was reopened for an aggravation of the original injury. The employer decided to let the worker go while he was off work, and took the position that they didn't have to bring him back. So WorkSafe immediately got involved on that one and said, what are you guys doing? This worker's on a claim. You've got a duty to maintain his job. And actually convinced the employer to reinstate the worker. Interestingly, the worker said, I'm not coming back. And so, the worker took the position that the way they treated me kind of broke the trust of the relationship. And so I'm not going back there. I don't have to go back there. So this is still being adjudicated by WorkSafe, but it's kind of an interesting scenario because the employer was arguably in breach. They then offered to reinstate the worker, and the worker said no. So from what I understand, I think the worker was paid benefits up to the time of the reinstatement offer, and then WorkSafe said, well, you had the opportunity to go back and you didn't. So we'll see what happens with that one, but obviously there's more than just WorkSafe in that sort of scenario. You've got potentially a wrongful dismissal. You've got issues with mitigation, should the worker have taken that offer, and you've got human rights issues, of course. So huge mess. The second example, the worker claimed to have injured his ankle in the shop and went off work. And then that ankle injury morphed into a back injury for whatever reason, I guess from limping. And ultimately, both of them were accepted by WorkSafe. During the period of absence, the employer got a tip that the worker wasn't really as restricted as he said he was. And so there was some surveillance done, and the worker was observed to be going shopping, getting in and out of his car, going to sports games, showing no level of restriction at all, completely inconsistent with what he was representing to both WorkSafe and the employer. So in those circumstances, the employer terminated for cause, and WorkSafe initially took the position that this is in breach of the duty to maintain. Employer, you need to explain yourself. And then we did a very fulsome explanation of the situation, and WorkSafe agreed that, okay, you guys, you're fine. But of course, we're dealing now with wrongful dismissal case. But that's another scenario. If you have, good reason that's totally independent from the injury, WorkSafe is going to be okay with you letting the worker go. The third one is a worker suffered post-traumatic stress at a construction site, was off work, and then during the period of leave, the employer had an economic downturn, and they had to lay off entire division, including this worker. And again, WorkSafe said, well, this worker's on a claim, you can't let them go. And the employer had to explain the situation would be no different if they were on the claim or if they're at work. They were going to be laid off with the rest of these 15 workers. They're not being singled out. And so we've yet to hear back from WorkSafe on that, but it's been 6 months. So I'm hoping that similarly they're going to be fine with that explanation. The other thing I'll flag is many of you have probably heard about the new employment standards protected leave that's being proposed. So we got the announcement about the sick notes coming into effect. You can't ask for sick notes. Someone will probably talk about that today. Yeah. So I won't steal Fiona's thunder, but are you talking about the leave too?
A little bit,
Okay.
but feel free.
But
Yeah.
What's being proposed is 27 weeks of unpaid serious injury leave. And so it's another protected leave to stack on to the suite of protected leaves under employment standards, in which you cannot terminate someone, in which you must maintain their job. And so you can imagine if someone's off on WorkSafe on a serious work injury, technically they also qualified for the employment standards unpaid leave. And so now you have kind of obligations under WorkSafe to maintain their job, obligations under employment standards to maintain their job. And it's just another potential complaint that someone can make, or another forum to be adjudicating the same issues in. So it just means more time, resources, and risk for employers.
Sorry, I have a question.
Yep.
Sorry. Example 3 that you provided where people were laid off and then someone's on WorkSafe and then WorkSafe's like, well, you can't lay off this person because they're in a claim, and then you're saying we're still waiting for the verdict to see what WorkSafe is going to say.
Yep.
Is there any chance we have a similar situation, and I just want to know, could we be notified in any way of what will happen? What will be the result of this?
Oh, like what happens in our case?
Yeah.
Yeah, maybe we can do a blog or something once we get the.
I'm very curious to know what's happening. We currently have a scenario like that we did let go someone, and now WorkSafe's approved and
Yeah.
they're reached out.
Yeah, I mean, I would say you can't be put in a better position than your fellow worker because you happen to have the work injury, right? If you would have been there, you would have been laid off too. But who knows how they're going to interpret it. But yeah, we'll certainly send out some sort of an update once we have that. Yep.
Oh, one question, so sorry. When can we apply?
When can we apply the frustration of contract between the employer and the employee? Generally, employees get injured at work. It's a WCD case. Employee trying to accommodate as much as possible, but things doesn't work. I just wanted to understand this.
Yeah, very good question. Frustration of contract is an interesting and complicated issue. What is interesting about the duty to maintain employment is that after 2 years of someone being off, the duty to maintain ends. And so you often hear about this 2-year mark. Is that a magic number where you can terminate someone? No. Oftentimes it coincides with if a person's on long-term disability, the change in definition of disability from their own occupation to any occupation. But frustration is very much a case-by-case situation. And ultimately it comes down to, is there any reasonable possibility that the individual is going to be able to return to work? And is that shown in the medical evidence? And it's returning to work in their previous position or an accommodated position. So you definitely got to seek advice every time you think about frustration, because you've got the WorkSafe, you've got human rights, and then you've got common law as well.
Thank you.
So moving on to mental disorder claims. So I just put up some data here. You can see from 2020, there were about 4,500 psychological injury claims reported to WorkSafe. In 2024, there's 7,300 almost. And I expect it'll be higher for this year. You can see the allowed and disallowed. And so there's an allow rate hovering around 50%, but interestingly, it was quite a bit lower at 46% for 2024. And I don't know if that's just kind of a random cyclical thing, or if there's more kind of frivolous claims being brought, or if WorkSafe is being a little more strict in how they're adjudicating these. I don't know exactly, but what we know from the data is that a psych claim has 4 times more, on average, time loss than a physical injury claim, and 3 times more claims costs because of the length, because of the additional treatment that's needed. And so it's an alarming trend to see the psych claims increasing like this year over year, from a claims cost perspective and from just a personnel and resource perspective. And as it stands now, to have a legitimate psych claim, you have to have a DSM-5 diagnosis from a psychologist or psychiatrist. And it has to be caused predominantly by a work-related stressor or a traumatic experience at work. It can't be a management decision, which I'll talk about in a second. So the criteria are pretty high threshold for those claims. What the labor movement wants to do is expand the definition of mental disorder claims to any mental injury, right? So like stress. And you can imagine how the claims are going to go up if the threshold changes from a diagnosed mental health condition to stress, or like, so I'm concerned about that. With that in mind, I think it's really important that employers do everything you can to get a handle on mental health in the workplace. Fiona will probably talk about that. But being proactive in dealing with issues before they turn into claims, before they turn into absences. Are you doing regular check-ins and assessments? Are you looking at your benefits package to see how you can support people? It's about kind of getting on top of it before it turns into absences. And I don't have the exact data, but I know that there's thousands of complaints, bullying and harassment complaints reported to WorkSafe every year. So I would guess that, maybe 25%, if not more, of these psych claims relate in some way to bullying and harassment. And so are you doing everything you can to prevent bullying and harassment in terms of having a policy, in terms of having an investigation procedure? All that kind of stuff is really important from a claims cost perspective. So yeah, I've just put up the test here, and basically it's interesting because the test for mental health claims is different than the test for, say, a physical injury claim. Physical injury just means that the work is a more than trivial cause of the injury. And so it really just needs to be kind of a small part of the causation, as long as it contributed a little bit. For mental health, it has to be the predominant cause. So it's a higher threshold. You need to show that the work event was a traumatic event or a significant stressor, and it was the predominant cause of the injury. And so and a WorkSafe lawyer took a run at this definition in a case called Pickering and said, this is not fair to have a higher standard for mental health. An injury is an injury. That's a breach of the charter. So there was a charter challenge, and the BC Supreme Court took a look at it and said it's actually okay to have a higher standard because mental health injuries are different in nature than physical injuries. And the research suggests that most mental disorders would have those disorders with or without job stress. And so because of that distinction, there wasn't a breach of the charter, and we still have this predominant cause test, which is good. It establishes a higher threshold. The worker also went after the labor relations exclusion and said it was overbroad, because the way that it's technically written, it says that any management decision is kind of immune if the mental health issue arises from a management decision. So a performance review, or even a termination, a demotion, changing someone's location, those are all kind of protected, where if the worker gets upset and goes off, they're not going to be able to make a claim because it arose out of a legitimate management decision. So the court looked at that and said that's too broad, because what if the employer is acting in bad faith? What if they're trying to punish the worker unfairly by demoting them? What if they're writing a performance review that's totally, not connected objectively to the worker? So those kind of scenarios, the court said, well, it shouldn't be interpreted that way. So it is in breach of the charter, but we're just going to read it down to mean that the management decisions have to be in good faith. And so, I don't know how much that's going to change the claims, but technically that could mean a little more scrutiny on the actual management decision that leads to the worker's injury. Was that a legitimate performance review? Was that a legitimate termination? I don't know if WorkSafe is going to start looking at that more closely to let more of these claims in that come out of people getting upset over workplace decisions, but we'll see how that plays out. Another case that came out, which I don't have on the slide, is a case called Vancouver Island Health Authority and Safei. So this was a case where a pharmacy assistant only worked a short time. She claimed that she was bullied and harassed and discriminated against by some of her colleagues, made a WorkSafe claim. WorkSafe investigated and determined that there was no harassment. And so WorkSafe interviewed the people that were accused and did a reasonable investigation, denied the claim. So this individual's WorkSafe claim was denied. She appealed all the way up through to WCAT, and WCAT upheld everything, and the claim was never processed. The employee then went to the Human Rights Tribunal and said, I was discriminated against. I want you guys to take a look at it. And the employer applied to dismiss the case and said, this has already been decided. WorkSafe has adjudicated these issues. What are we doing here? And the tribunal said, well, maybe we'll have a hearing. We don't want to dismiss it. We have jurisdiction over human rights, and so maybe we'll see it differently. And the employer did a judicial review of the human rights decision. So the BC Supreme Court looked at it and said, Human Rights Tribunal, you guys didn't look at this properly. You failed to recognize the exact same set of facts that's being put in front of you has already been dealt with through the WorkSafe process. So WorkSafe did a legitimate interview and investigation process, and those findings that they made, which were upheld on appeal, those really can't be relitigated in another form. So the case was sent back to the tribunal to actually look at it in a different way. And the tribunal now, I think, is going to have to dismiss the case, but we'll see what happens. But that kind of shows that the courts are going to respect WorkSafe's decisions and adjudications on these types of issues. And oftentimes, WorkSafe is the first kick of the can because things happen so fast. So getting involved in the claim, putting your best foot forward, making sure all the information's before the investigator and the WorkSafe adjudicator is really, really important because it could have implications for the subsequent complaints that are going to come down the road later.
May I interject something? So I recently had a file where I was retained as an independent third-party investigator for the employer, and WorkSafe BC required them to do that. So I think one of the outcomes of that second case is WorkSafe BC is going to say back to the employer, over to you to investigate. Because WorkSafe BC, what they're doing is a pretty cursory talking to everybody. And it's not going to rise to that level of a workplace investigation report that would be evidence at the BC Human Rights Tribunal or be evidence in a wrongful dismissal case if you choose to dismiss somebody based on a report. So just be aware that I think a consequence of that case is you as employers may get told by WorkSafe BC, you need to be in compliance with your legal obligations, conduct the workplace investigation.
Okay, I'm going to talk a little bit about the reviews and appeals process. So anyone that has dealt with WorkSafe knows that when a worker goes off, there's many, many decisions that are made on the claim. And as the employer, you get copies of these decisions. A lot of times you might just kind of put them aside. I don't know what this is. But sometimes the impact of those decisions could be really substantial for the claim and for your claims costs and for the worker. And so in a lot of cases, it makes sense to take a close look at them and see, is this something that I want to appeal? So I've set out a little bit of information about the appeal process, and I'll talk a little bit about the levels of appeal. The review division is the first level of appeal, and it's still technically part of WorkSafe, but it's it's a different division, I guess. And review officers are employees of the review division, and they have the mandate to decide these appeals, these first level appeals. Both the worker and the employer have a right to appeal any decision. And the reviews are generally conducted by written submissions, so it's not an oral hearing 95% of the time. You can submit medical evidence and other evidence with your submissions in addition to your argument. There's a statutory requirement that the review be completed within 150 days, and that's actually the average time for a review to be completed. So it's not super fast, but it's definitely faster than some other appeal processes. I have some data here on the outcomes, and you can see in the first 2 quarters of this year, there's about a 43-44% rate where the review officer confirms the board's decision, so the appeal is denied. And then there's a 34% rate where the review varies the board's decision, so that would be a successful appeal. And then 22% are referred back to the board for a new decision. So what we can see from this is you've got a greater than 50% chance on average of changing the decision. It's so, those are pretty good odds if you don't like the original decision. And I don't have the data on how many are like worker appeals versus employer appeals. But I would say the vast majority of these appeals are brought by the worker. That being said, the review officer really doesn't give a ton of deference to the original adjudicator. They will look at the case with fresh eyes. And, if it's something that's really going to impact the claim, you have a decent shot at getting a different outcome. The second level of appeal is the final level of appeal. That's the Workers' Compensation Appeal Tribunal. The WCAT is more of kind of almost like a court. And so the vice chairs will generally be lawyers or have some legal training. You have 30 days to appeal to WCAT versus the 90 days you have with the review division. So it comes up fast. And there's a new provision that came out in 2023 that allows WCAT to order a medical examination, an IME. So this was requested 55 times last year, and 10 of those requests were allowed. So that's just a tool you have potentially if you think, because often an employer can't, force an employee to go to a medical exam for the purposes of this appeal. But if you ask WCAT, you say that we have good reason to think an independent medical exam will be valuable for the issues in this claim. That's a tool you have to ask WCAT to order that to happen, and they cover the costs as well. So you don't have to pay for it. I have a table here with some of the data for appeals. So of the about 1,800 decisions last year, 64% of them confirmed the review division's decision, so that denied the appeal. And then 33% varied the review division's decision. So even if you go one level up, you've got a greater than 25% chance on average of being successful. So a few tips here for the appeals process. What are some of the decisions you might want to appeal? Entitlement decisions. These are the first level decisions from entitlement officers saying, is the claim accepted or not? So do you have an argument to say, this is not a work-related injury, or this is not a work-related event? That's your opportunity to make that argument and have the claim denied. Once the claim's accepted, there's wage rate decisions made, where the wage rate officer says, based on the information I have, I'm going to set a wage rate of X. Those are important decisions because that wage rate stays the same for the entire claim. There's a short-term wage rate done, and after 10 weeks, there's a long-term wage rate set. So that's worth checking to make sure the calculations are right. Healthcare cost decisions. So the worker may be entitled to, physio or massage or some other healthcare. Is that treatment reasonably necessary for the injuries? That's something you can look at. Modified duty offers. Have you made a reasonable offer for the worker to come back in a modified role while they recover? If WorkSafe adjudicates that and you disagree, that may be a decision worth looking at appealing. Pension decisions. So once a worker reaches stabilization and it's deemed they have a permanent disability, there's going to be permanent disability awards assessed. And those can be massive, right? Those can be hundreds of thousands of dollars over the length of the claim because they're payable by default to age 65. And you get hit with the claims cost, I think, immediately. So, you can look at those. Is this the appropriate level of disability? Is this permanent condition reasonable? Cost relief is another one. So if the worker's injury has a non-work related component, you can get relief of your claims costs up to 100%. And so those are decisions that you can appeal if you disagree with how WorkSafe is kind of assess the non-work versus the work-related causes. And then vocational rehab is a big one. So do you agree with WorkSafe decision on what this worker can and can't do in terms of their restrictions and limitations? Do you agree with WorkSafe decision on whether they can come back to your workplace or not? Do you think it's appropriate for them to be going on to another phase where your claims costs are going to increase substantially? If you do appeal, one advantage is you get the entire claims file for the worker. So this is going to have pretty much every communication they've had with WorkSafe. It's going to have all of their medical records. You're going to get a lot of detail about this claim. So those are often fruitful for a number of reasons. One thing to be mindful of is you cannot use a WorkSafe claim file for anything other than the WorkSafe claim. So if you have another proceeding going, you can't make use of those documents without consent of the worker and or the tribunal or court. That's something built into the WorkSafe legislation. Other thing you want to consider, do you want an oral hearing? Is this something where you think the worker's not credible and you can question them or have the lawyer question them? Or is it something that's better by written submissions, which is a more streamlined process? And then I've got a note, 2 resources, the Employer's Advisor's Office. This is a free resource for employers that are dealing with WorkSafe claims. It's kind of the other side of the Workers' Advisor's Office, which provides free help to workers. So I'm not trying to put myself out of business, but some claims just doesn't make sense to have a lawyer. And if you feel out of your depth, by all means, reach out to the employer's advisors. They can give some advice over the phone about things. And in some cases, they can actually give you representation. And then finally, the Issue Resolution Office. So this used to be the Fair Practices Office. If you're having a problem with how WorkSafe is handling the claim, so an issue with the case manager, or an issue with the length of time it's taking, or an issue with not being able to get a hold of someone, call the Issue Resolution Office. You'll get a call back within 24 hours. And they actually do jump on the case and deal with things. So it's a good resource.
Chris, yeah, I actually didn't know about the Issues Resolutions Office. Do we just like Google it and find the phone number and they,
Yeah.
Are they like a government, they're just a separate private part of the
I think
WEA?
it's government funded.
Technically, it's within WorkSafe BC, but it's independent of WorkSafe BC.
Yeah.
And yes, if you go to the WorkSafe BC website and go to that search engine and do Issues Resolution Office, you'll find some info there about it. Yeah.
Thank you. Yeah, great.
I have one question. With the offer for modified duties, if a worker say goes off a back injury, they have a doctor's note saying they need 4 weeks off, 6 weeks off, and you have like duties or modified duties, does the worker have an obligation to accept those? What is their obligation to participate in that process?
Yeah, so we had a question, if someone's off with, say, a back injury, they've got a doctor's note, you're off 4 to 6 weeks, but the employer has modified duties under which they could come back to work. So yes, you certainly can make them that offer of modified duties. There's a whole regime within WorkSafe on evaluating whether that's a reasonable modified work offer. Generally, it has to be safe for the worker. It has to be something that's not like demeaning or like token work. So, sitting and watching videos all day or something, or doing something that would be demeaning for the worker, those types of things, no. But if it's like legitimate modified work that's within the worker's restrictions, absolutely you can make that offer. You're obligated, I would say, to make that offer. And that's a really good way to reduce your claims costs. If WorkSafe agrees with it, and they'll tell the worker, you need to accept this. And if they don't accept it, they'll stop the claim. So yeah, very, very good option for employers to have.
And just one follow-up on that, do you typically route those requests through the WorkSafe case officer or directly to the themselves?
Yeah, so I think you want to do both. The duty to cooperate is kind of like, it's a 3-way thing between the worker, the employer, and WorkSafe. And you want WorkSafe to know what your offer is, so they can properly adjudicate the suitability of it. So absolutely through the case manager, and making sure the worker gets it too. Okay, so my final topic with WorkSafe is prohibited action complaints. Can I get a show of hands for people that know what these are? Okay, so not a whole lot of people. Prohibited action complaints arise when a worker brings up a health and safety issue in the workplace, and then there's a reprisal, so like a retaliation against the worker for exercising that legitimate occupational health right or duty. And if a worker is able to prove that a prohibited action has happened, they can order reinstatement of the employee. They can order that reprimands be removed. They can order payment of wages and other expenses that the employee has lost. So in 2024, this is data we got through the Employers Forum. We had a chat with the Prohibited Action Division of WorkSafe. The events that are mainly triggering these complaints, 56% of them are bullying and harassment. And so how this would play out is employee files a bullying and harassment complaint. Under the policy, they believe that they've been bullied. The employer then, in response to that, terminates them, demotes them, starts treating them negatively. Basically, there's a reprisal for the worker bringing up this bullying and harassment. So making a harassment complaint is considered an exercise of a health and safety duty. The second one is a concern about an unsafe work condition. And so I think this is kind of, how prohibited actions were initially imagined was, someone on a construction site says, oh, there's a giant hole there without any, it's not safe. And then they get fired for doing that. That's the second most. And then the third is someone just bringing up the fact that they've had a work injury. And I've got a note here to say that just making a WorkSafe claim is not considered exercising a occupational health and safety duty. It's got to be something more. Like you've got to be pointing out something that's unsafe. You've got to be making a bullying and harassment complaint. And interestingly, the worker only needs to show that they had a reasonably held belief of an unsafe condition or of bullying and harassment. If it turns out that the workplace was completely safe, or if it turns out that the bullying complaint was not legitimate or not founded, it doesn't matter. It's the fact that the worker had a reasonably held belief in the unsafe condition that gives them the right to bring this prohibited action complaint. So I've got a slide here on kind of the life cycle of a prohibited action complaint. The worker files it online. There's a screening that gets done internally with WorkSafe to make sure that it fits within the test generally, that there's no jurisdictional issues, that it's within 1 year, which is the time frame. And then a notice goes out to the employer to say this prohibited action complaint has been filed. Do you want to have mediation? And if the employer says yes, then there's a mediation set up through WorkSafe. WorkSafe provides a mediator. Usually that's within 6 months, I'd say, of the initial complaint being filed. If you say no to mediation, or if you don't settle at your mediation, then it goes on to the hearing process. The hearings are generally done through written submissions. So the worker will provide all of their evidence to say, why they feel they brought up a health and safety issue and how it's connected to them being terminated or how it's connected to them being treated negatively in some way. And then the employer will get a chance to say its side of the story in terms of this is why we terminated. It had nothing to do with this bullying complaint. It had everything to do with all these performance issues. And here's the warning letters. And here's our internal discussions on why we were going to terminate this person. So that's kind of how the process works. The hearing process is done in 2 stages. So the first part of the hearing is to do with liability. So the only thing they're looking at is, was there a prohibited action? Was there retaliation for the worker exercising their rights? If it gets past that, then it goes into a second phase, which is remedy. So what's the appropriate remedy for the worker? The worker might want to be reinstated if they've been dismissed. The worker might want to be made whole for their financial losses. So that second part is when you get into the remedy piece after liability has been established. And there's an appeal available to WCAT within 90 days of either decision. And so you may find yourself in a scenario where there's the liability decision, you've appealed that to WCAT, and then you're making your submissions on remedy to WorkSafe while the liability appeal is pending. You don't get to stop the process. So yeah, it's not a fun process, but if you're in that remedy stage, there are a number of defenses available to you. One recent one I had on one of my files was, we argued that notwithstanding this health and safety issue, the worker was going to be terminated in any event for other reasons. And so if you just take the health and safety issue completely out of the equation, there was enough other stuff, non-discriminatory stuff, whereby the employer it could be inferred that the employer was going to let this worker go. And WorkSafe actually agreed with that and said, even though we're finding liability, we're not going to give any wage loss for the remedy. And so it was kind of an empty award for the worker, because WorkSafe agreed, you would have been gone regardless of the fact that you made this bullying complaint. Okay. So I've got a little bit more data here on prohibited actions. So again, concerning trend, we can see in 2020 there was 659 files, and then last year there was 807. So there's substantial increase over the last few years. That's kind of what we've been seeing anecdotally too, is there's just more of these prohibited action complaints happening. And you'll hear from probably Courtney and Roan about the delays with the Human Rights Tribunal. The prohibited action process kicks in within a few months, whereas other processes are taking a year or more. And so employees council are often like shoehorning complaints into a prohibited action regime just to be able to get the process going and get into that early mediation where you could potentially resolve other claims too. And I have actually done that on both sides for the employee and the employer, use that prohibited action mediation to resolve larger issues. So just some tips here in dealing with prohibited action complaints. So if there is a worker raising an unsafe work issue, deal with it right away. If it's the type of issue where they feel there's an unsafe workplace, there's a procedure to follow under section 3.12 of the regulation where you've got to assess it, and then you can get WorkSafe involved if you and the worker disagree over whether something is safe or not. If it's bullying and harassment, get on it right away and follow your policy, do an investigation. And there can't be any reprisals for the worker that brings these things up. It's often very difficult because a worker that may be on the brink of termination and knows it could take advantage of this and raise a health and safety issue. And that's where you get into a risk management decision of, well, do we have enough here to let them go anyway and be able to defend the prohibited action when inevitably it comes. Take advantage of that early mediation. As I said, WorkSafe will give you a mediator. The mediators are generally good. They have training with prohibited actions, and so they know what they're doing. And it may be a way to get a full and final resolution before those other claims come down the pipe. And I already talked about the defense system make whole remedy. Yeah, so what's coming? So hopefully WorkSafe will continue to kind of hold off on major changes. Looking at the work plan for next year, I know they're looking at chronic pain. So as of now, if someone is accepted to have chronic pain in an area of their body, they get a 2.5% disability award. So many people feel that's unfair. So my guess is that that's going to be changed to the detriment of employers. They may raise the cap on chronic pain. Maybe it'll go up to 5% or 10%. But I expect there'll be changes there. They're reviewing additional benefits being made available to people with severe injuries. They're looking at the cost relief system, potentially in a good way, because that was requested by, I think, the employer's form. Mental disorders I've talked about, they may be expanding that. Prohibited actions, they're looking at that whole regime as well, so that may change. And then this concept of the psychologically safe workplace is still out there. So lots of stuff potentially coming, but as of now, hopefully we'll have a slower year in 2026. Okay, so I think we've got 5 minutes for questions.
I have some virtual ones, Chris.
Okay.
Good faith, oh, sorry. Okay.
We're working on. Good faith, sounds like it'll be challenging to prove. Any suggestions?
Yeah, so I'm assuming this relates to the labor relations exclusion, where you need to show the management decision was made in good faith. So I think, acting in good faith just means objectively, is your decision reasonable? Is it well considered? Is it consistent with your existing practices? Have you been fair and respectful to the worker? I think as much as you can document and follow your policies and be consistent with your systems, better chance you have for something to be seen as just good faith and a regular decision, not punishing the worker.
Okay, and then just to clarify, it was 2.5% of what exactly?
Yeah, so the way the pension works is the long-term wage rate gets set on the claim. So for example, let's say a worker's long-term wage rate is they'll get $5,000 a month. And while they're off on the claim, they're going to be paid $5,000 a month from their WorkSafe benefits. If their pension is 2.5%, they're going to get 2.5% of that $5,000 on a monthly basis, paid out as their disability pension award until the age of 65. So that's how the percentage works. If it's found that they're 10% disabled from, say, a psychological condition, then they'd be getting $500 a month up to age 65. So if they're 20 years old, you can imagine how much that costs.
Chris, you mentioned Chris, you mentioned that it was a cap at 65, and when you look at the navel gazing of the NDP and they see all that money sitting in WorkSafe, do you think they're going to move that up?
They have been already. So there is an ability actually for employees who are getting that disability award and hitting kind of 63. There is actually a policy in place that they'll get contacted to find out what their realistic expectation is of work to 75 or past 65. So you may hear about that. I think the letters also go to the employer, just so you're aware. But it really is kind of an employee decision to say, no, I wouldn't be retiring at 65. I realistically, because I've got a mortgage still, I've got children, I've got to pay for education, I've got other finances, I can't not have this $250, $50, $500, whatever it may be. So there is that already happening under a policy of WorkSafe BC to review at about age 63.
Yeah, that's right. They used to assess the retirement age at the time they awarded the pension. And so a 35-year-old would have to tell WorkSafe, I think I'm going to retire at 75 instead of 65 and WorkSafe. So that doesn't make a whole lot of sense. So now they're doing that assessment at age 63. Okay, so that takes, oh yeah, one more question, Lori.
Yeah, sorry, slide 14, I was just looking at the reviews and appeals WCAT.
Yep.
And in the provision about WCAT can order its own IME.
Yep.
What happens if you get that and as the employer you disagree with the IME? Can you then contest that or ask for another one, or is it done?
I think you can make submissions that you disagree with it, but it's there, right? And WCAT's going to consider it, and I think the idea is it's meant to be an objective, independent. So you kind of do it at your own peril as the employer, and you have to live with whatever it says. But certainly you can argue disagree with it. But if you're the one that requested it, it's kind of
You'd be attacking the credibility of that expert, of that independent assessor, and that's always a bit of a challenge. And you'd want some legal advice on that one for sure, because it is. Yeah, it's supposed to be an independent medical exam. So if you're really questioning the independence, then and you requested it, that just doesn't look great.
So WCAT requested it. WCAT requested the IME, not the employer, but the employer looks at the IME and goes, oh, this doesn't.
Oh yeah, so if WCAT requested it kind of on their own motion,
Yes.
then you're in a better position
Yeah.
to disagree with it.
Yeah,
But I
Okay.
don't think there's gonna be many cases where WCAT on its
Yeah.
own
we do it.
triggers that.
Yeah.
It's got to come from either the worker or the employer. Say we want you to make this order. So yeah.
Well, good morning, everybody. Boy, this is cozy. I like this, I don't think I'll wear a tie next year. First of all, I apologize. Every year I do this seminar, I get a cold and I get talking, I get dozy. So if I get dozy, I apologize for that. The other thing is I wanted to get here early, to sit around, have a coffee with people and meet people in a more informal setting. But I don't know if any of you have seen the Seinfeld where they spend half an hour in the garage trying to find the car. Well, that's me. I was trying to find one of those pay things that didn't say get a coupon. I have no idea. So I'll figure it out for next year. Two things before I get going here. First of all, I'm going to be dealing with the provincial labor relations code, not the federal code. So if you're a federal employer, please, follow up with me whenever, and I'll do the same answers for you, but in the federal sphere. So I think I saw in looking at the attendee list that some people may fit into that. So, but we certainly will follow up. Just give me a call and we'll arrange a call and I'll take you through the shinny on that. And the other thing is, I'm sure you've experienced this, but anytime your lawyer says, that's a really interesting question, right? That's when you go to the vault and pull out whatever money you've got left over. So today we will have some of that, but I think we'll be able to give you some directions a little bit clearer. So I asked Chris to put this topic on about unions for a couple of reasons. One of them is the Labor Relations Board has just hired a whole bunch of vice chairs, right, that adjudicate things. And so that suggests to me they're expecting a lot more applications to be coming to the Labor Relations Board. And the ones that make the applications usually are the union. So that's one thing. So you've got to be, the other one is the economic outlook. I'm sort of like the cheerleader for an accident. I think we're going into a serious recession. I hope to God I'm wrong on that, but just sort of reading the tea leaves, you have to think that there's a problem. Why is that relevant? Well, if you're in an economic slump, you're going to see employees maybe being much more open to joining a union and being promised all these things. So that's one reason. The other thing is union organizing, I think it's pretty obvious that it's on a huge uptick. The trends are that the numbers of certification applications, everything are higher. Plus unions have a lot of money now, right? The government gave them the Patella Bridge and a bunch of things so that they're going ka-ching, ka-ching, ka-ching. And unions are like businesses, just like your business. And they make their money by getting more people signed up and getting certified and getting dues collected, right? So it's a business deal and they're very good at it. And so that's what you have to understand about why we're there. But So I looked at the attendee list to see if I could be talking to people that could find any of this interesting. And there are a whole bunch of you out there that are non-union, at least now. I don't know, maybe you get a call from the labor board before we leave, but right now you're non-union. There are some of you that are hybrid. By that I mean you've got a portion of your business that's union, but a portion that's non-union. And then some of you have no interest at all in unions. But I've got stuff for you because you could contract out something and find that your business is unionized, even though you have no connection to it. It's got nothing to do with your employees. So that's why I think all three of you will have something out of this program. At least I hope so. The goal here is to provide you with some takeaways for all three of you, and just to think about when you're going. So there's a 5-day certification sprint, right? You're sitting there on a Friday afternoon, you're getting ready on a long weekend, and bingo, this is Alice Smith from the Labor Relations Board, comes over the facts, and there's an application for certification. And by the way, we'll be having a hearing on Wednesday. And that's sort of how fast it goes. So what I'm going to try to do is provide you with some kind of run of what happens, what Chris and I need to know when you phone us on Saturday and say, we got to be at the labor board on Wednesday, what do we need to know? Okay. And so I think if you've thought about it in advance, the amount of time it takes me to explain to a poor, you get the client, the employer, it looks like a deer in front of the headlights, like what happened? And so trying to get across how the whole process works, I think it's useful, and that's why I think the program today will be of some use to you. I'll also talk about this goofiest section, I think it's 35.2, which talks about successorship, where you contract out your security, and then all of a sudden you change security companies, and they're automatically certified. So it's like being unionized on your business without any employees. And so the people may be found to be doing that. So at the end, I'm going to tell you how to stay non-union. Put Chris and I out of business, just fine with us, just like at the worksite. We got lots of other stuff to do, but we'll maybe share some tips, and I'd be interested to hear what your views are of why your workplace is non-union and why it should be. And then finally, I'll talk about the Bill 3 report, where the government puts 3 wise people on to do a report about what changes should happen. The NDP do these all the time, and then they make big changes after. They say it's balanced, it's not. And so we're waiting for the new labor minister to decide which out of the elements in the report on August 31st that came out, she's going to pick and choose what she wants. And guess what? I don't think we're going to win. But at least we've been pitching, and you'll hear about the pitch that the business associations that we're part of and others are there. So here's the agenda. I'm going to give a brief history of labor relations. I'm going to talk about what does it mean to be unionized, be certified for a group of employees. I'm going to talk about the certification process. I'm going to spend some time talking about that because it goes quickly. And what I'm going to be looking at is, the distinction between if you had a secret ballot vote, which 90% of the cases are not a secret ballot vote. So I'm going to be talking about that process, the formal thing, who you're going to be hearing, and what possible defenses Chris and I can figure out for you. I'm also going to talk very briefly about unfair labor practices. I don't know if you've heard that expression, but they are when employers take action that is contrary to Section 6 and Section 9 of the code, or Section 6 and 9. And if you take action, here's a union, I fire everybody. That type of conduct that tries to interfere with their rights, which are now a charter right, to be unionized. And then I'll try to give you some practical advice before the union comes knocking. And then, can it get any worse? Well, the Section 3, I'll give you the shinny on that. So let's just look back at you only look back for the purposes of looking forward. But in 1992, the NDP came in. You had Glenn Clark, you had Mo Sahota, and they were successful. And they came through, and they had one of these Section 3 type committees, and they came up and they had 44 changes to the labor code. I remember it distinctly because we did a news thing. 41 of them were in favor of unions. And from that point on, union certifications in this province from 92 to 2002 were extraordinary. They just rose exponentially. And one of the big things was they got rid of the secret ballot vote, okay? And they also made it very difficult for an employer to say anything. So employer free speech were really hammered with a whole bunch of other things. And then in 2002, Gordon Campbell comes in. He's part of the BC Chamber of Commerce. We were part of, discussion groups leading up to that election. What should we change, et cetera. And a couple of fundamental changes were made that we'll talk about, which is they brought in the secret ballot vote. And they also opened up an employer's right to talk to you and talk to the employees about their business and be able to actually say, I don't want a union, but it's your choice. And so those two changes, there are other ones, but those are the critical ones. And guess what? Certifications nosedive. We rarely lost, not rarely, but usually when employees are in a ballot or in a secret ballot and it's theirs, the true answer is they don't want to be a union. I mean, that's my maybe jaundiced view of it, but why did we win all these votes? I don't know, but I think that's maybe part of it. So 2019, NDP are back in, but they're married to the Greens. And so again, it's deja vu. They're another big commission, three-person panel, comes out with a whole bunch of recommendations. But the one thing that was interesting is that the Greens said, you got to keep the secret ballot vote. That's so contrary to democracy that, and so that's why the secret ballot vote was in. So it wasn't quite as bad as it could have been. When I say could have been, 2021, new election. Everybody has a view of why that was called. But immediately, the minister got rid of the secret ballot vote in 90% of the cases. I'll talk about it. But again, it is back to 1992. And I was quite busy in 1992 doing union work. And I kept all my precedents. And since the language is now almost identical to 1992, all these young lawyers running around, I've got all the things. I've got the scars on my back to show. So anyway, so it's game on now with where we are. So what does it mean to be unionized? Right, to be certified? Well, what does that mean? Well, what happens is the labor code says that the union becomes the exclusive bargaining agent for your employees. You've now got a third party that is between you and your employees. Okay. Immediately upon filing, terms and conditions of employment are frozen, except you can make some when we find out how you can do that. They stay frozen for 12 months after the certification or until you get a collective agreement. You can only dismiss people if you have, quote, proper cause, which is far less than just cause, but it's a standard. And the odd thing is, if they're organizing and you don't know about it and you terminate somebody, the proper cause applies. So it's crazy, but that's the way it is. So you may find that if a termination happens or discipline of kind, that you're caught by that. And so the idea is that you then, once you're certified, you got to sit down and say, okay, let's negotiate a collective agreement. And then the certification gets replaced by the collective agreement. And that's what governs the terms and conditions for all of the employees in the bargaining unit. Okay, so that's what it is. You can't cut deals with your employees. You can, but you're going to get slapped by the union. And there's lots of other things to consider. What happens when we go on strike? What about picketing? What about, I want to use replacement workers? There's a whole bunch of things that come in that emanate from this original being certified. So the bottom line is, if you can avoid being certified, you may avoid a whole bunch of problems. And operating under a collective agreement may be okay in some sense, but generally it's not good. And what you want to do is not have Chris and I on your speed dial. But if you get certified, we'll be on your speed dial. That's just a fact of life. So let's talk about the process. So it starts with the union going and signing up people, right? And, there's no sort of guidelines to what they can say and they can do. But that's the nature of the certification, because it's based on cards signing up that they used. And so I've given you Regulation 3, which sets out the criteria for what a union has to prove in order to sign up. What they do is they join the union, right? It's a membership card. And again, if you have any doubt about Harry Bays, the former labor minister, where he was coming from, it used to be the cards were good for 90 days, right? They sign them up and then they have to, check in. He moved it to, without any discussion, just moved it to 6 months. So they can have a card signed 6 months earlier, less a day, and they can use that. The employees can revoke their union membership. They've got to sign a clear statement, send it to the labor board before midnight, the day that the application is filed. And we've had lots of cases where if an employer is fortunate enough to have some people that think this is crazy, they can perhaps get some people to revoke, and then that may impact on whether the union has enough for automatic certification, okay? So what happens is the union does it, or the labor board does an audit. There has to be a high degree of integrity in the cards. We've had cases where we've been able to prove the cards were improper, or they didn't comply with the regulation, so they got to be tossed. And they've got to be upfront about it. There's been some cases where the unions are clearly making it up, putting people's names in, because they can sign up online, and that's, I think, a very dangerous thing, but that's what it is. Okay, so I don't know where we are on the slides here. It's shitty. The LRB notifies the employer by fax and phone. They order a hearing within 5 business days. So it's a common tactic for the union, as I said, to file on a Friday, and you had a hearing on a Wednesday. And I use that example because Chris and I had that this past year, and but we were able to be successful. But we had to move quick, and I was the client's worst enemy because I wouldn't put up with, we don't know, get it, The employer has to provide payroll information to the investigating officer. There's a report that's prepared. I don't have one, but if anybody's interested, let me know and I'll send you a copy of a template of what's in the report. But it basically says we check, these are the number of people that are excluded because their managers are confidential and yada yada, and they give a tentative voters list. So the motto is like the Boy Scouts, you got to be prepared, because if you're prepared, you may, in some cases, be able to avoid the certification. Unions often file unfair labor practices. Again, if you fired a bunch of people, you said, if you join the union, I'm going to, blow your car up or something. Section 1441 was amended to make it very easy for unions to argue your misconduct was such that we should be automatically certified, even if we don't sign up 55%. I don't know if I put this in the slide, but if a union signs up 55% or more of the people in an appropriate bargaining unit, that's enough for automatic certification. So they will often apply, if they haven't signed up enough, if you fire somebody who you know is the union organizer. And we've got one case, this is how crazy it is. 2 out of 80 employees had signed up with the union, and that was enough to automatically certify the employer. And it is what it is. There's another thing to bear in mind. There's a section 5.2, which allows a union to force a hearing within 3 days on unfair labor practices. Rarely is it used because it's not great for the union. But remember, they have all of the time to think about what they want. You have no time. But that's an option that the union can file. Okay, so you go to the hearing. If the union signed up more than 55%, and there's no issues regarding the appropriate bargaining unit, inclusions, exclusions, et cetera, if they got 55%, it's over. You will be issued a certification that the union is the exclusive bargaining agent. If there's an unfair labor practice, they may order remedial certification. Rarely these days do I see, Chris and I don't see a lot of applications between 45% and 55%, which would generate a vote. But sometimes when you get into the hearing, you can knock out a few people and their numbers come down. And so it's kind of a guesswork. But generally, I think unions are pretty smart. They know what the bargaining unit is that they want, and they know to make sure they get wiggle room with people in a row. So that seems to be our experience anyways. There may be some outstanding issues about unfair labor practices, inclusions that I'll deal with later. As I mentioned, there's a freeze in place. You can't change terms and conditions of employment unless you can show that it's, quote, business as before. we already had planned to do this, and so we can go ahead. And the other thing I'd mentioned it, Section 6068 was very draconian legislation brought in 92, which said during a strike or lockout, you cannot use replacement workers. I mean, it's very technical stuff, but you can't, right? And so it's like clapping with one hand. I mean, you're trying to carry on your business, and the union gets to have their people go on strike, and you can't run your business. And unfortunately, we couldn't get Gordon Campbell to push hard to get rid of that. We tried, and he didn't do it. And so I don't think that's ever going to change. But it's something, and the reason I mention that is it relates to when an employee is hired and when the notice to bargain is given. So if you're certified, what's going to happen is eventually the union will give you a notice to bargain, and you automatically have to sit down and bargain in good faith. But if you hire people before that, they're not covered as replacement workers. So, 15 extra managers show up, well, we'll argue it down the road, but that gives you some leeway. I always make sure I mention that to the client. If you are planning to hire people, do it now, not after you get the notice to bargain. So those are the kind of technical little things, but you got to be, if there are exclusions or unfair labor practices, what the board will do is take the vote and put it in the can, and then they'll go and they'll fight. Sometimes they will double seal the ballot. So if Chris I'm challenging him because he's a manager, or the union challenged him because he's a manager, he can vote, but they'll put it in two ballots. So they can know that it's Chris's ballot, but when they open it up, they won't know how Chris voted. I don't know how they do that when they do electronic voting, but what can I say? So what are the issues that you may find there? Just because the union gets 55%, it's not over. There are arguments to be made. One of the critical ones is, has the union applied for an appropriate bargaining unit? An appropriate, not the most appropriate, because the most appropriate is everybody, right? Everybody in my business is unionized, but they could go for a smaller slice, which they often do, okay? And so is the bargaining unit applied for appropriate for collective bargaining? The board laid out in an initial case the community of interest test for determining whether or not the unit is appropriate for bargaining. There's two concepts that they're trying to play with here. The first one is, we really want to give access to collective bargaining. That is what we want to do. But we also recognize employers don't want industrial instability. But here's the deal. On an initial application, it's access to collective bargaining is the primary concern. A second application where they're adding on more units, your salespeople or whatever, well, we will say in that industrial stability, should you have a separate, that type of thing. And there's a recent case that I'll talk about where they actually use industrial stability on the initial application. So I'm going to use that more often, I think, now that what you're applying for is not reasonable, okay? So the idea is it's a building block, right? So you take 10 out of 100 employees and you get certified. And then you get an application to organize another little group. And if you can show a defensible boundary around that group, you get them certified, right? So what the labor board looks at, and I've given the 4 critical tests: community of interest, similarity of skills, interests, duties, and working conditions, the physical and administrative structure of the employer, functional integration, and geography. Those are the 4 critical ones. And so I put in the next slide a quote from a leading case, about what the functional relationship is, because you're always going to have functional relationships in your business. The critical thing is, and the board acknowledges you have to have that to operate. But on the next slide is the critical distinction. Functional integration is different than functional relationship. Right? What they mean is that you've got to show that there's an employee interchange, a share of duties, integrated job duties, overlapping duties, team processes, continuous work processes, those type of things. But you'll see in the cases that what, it's the duck theory. If it waddles and quacks like a duck, of course we've got functional integration. Well, in fact, the labor board is saying not really. You just got a functional relationship. The board will then examine the nature, type, and extent of the functional integration to determine whether the proposed bargaining unit structure will result in a viable collective bargaining, really, given the principle of the importance of access to collective bargaining. So they kind of have their eye, well, how would you do the collective bargaining if we certify this group? Like, will it work? I mean, it's got to be realistic, right? And so I put 4 cases there. The first couple, I noticed that there are a number of car dealers that are in the audience virtually and in person. And so I've always thought of these cases when I'm dealing with a car dealership. And the one of them is the Granville Toyota. And this one was interesting because Granville Toyota had 2 operations, one on 41st, and I forget where the other, one's on Fraser, that's right, one's on 41st. And so the union applies for one, and the employer says, no, we are functionally integrated with our 41st operation. And the labor board, they generally say this, look, if you're going to say functionally integrated because you've got people from outside that come in, right, it has to be, as they say, it has to be a consistent managerial policy of functional integration. It can't just be the odd time I had somebody come in for holiday replacement or sick leave, right? But this case is interesting because that's what these people were. They were the parts people and I think one of the parts people and the runner would work between the stores, but often just filling in for the other people. Anyways, the labor board said, no, we dismissed the application because you didn't go for the other location. The only appropriate bargaining unit would include the other location. And so that was quite a victory, I think, for the employer. They weren't prepared to second guess the original panel. They said when there has to be kind of a daily interchange, they don't mean day to day. They just mean a consistent managerial policy. So you can see when you're sort of sticking a pin in some of these things, I wonder, right? If you're looking ahead, do you have a consistent managerial policy of moving people around? That may be to your advantage, right? But you can't do it after the fact. The other one is open road, application for all technicians who perform vehicle maintenance and repair and apprentices. It's what was interesting is the labor board accepted the union's evidence. Guy'd been there 30 years. The manager that spoke on behalf of the employer had been out of the area for a while. So at the end of the day, there's a conflict in the evidence as to what the integration was, and they accepted the union employee's evidence, which was critical. The issue was whether or not excluding the service advisors and the warranty advisors rendered the unit inappropriate. The latter had different skills, et cetera. There were no real employee interchange or shared duties. And you can imagine when you go to bring your car in, you deal with the service advisors. They're pretty hands-on, but they're not in there with the grease and the rest of it fixing the car. There wasn't a continuous work process, right, where they fix one and move to the other. There were interactions. They acknowledged that. They also acknowledged that, the service advisors have a similar pay structure that depends on the technicians, and so that's pretty critical. I mean, that's critical, but not critical enough. West Coast is an application for certification for the non-sales warehouse employees. They went and looked at the union showed up with an application to vary the certification because they said, we've got another location that's unionized. And the labor board said, no, there's no evidence that there's any integration or whatever, and there was no evidence of it. Then the union came back and said, well, we want an amendment to allow us to just go for the one unit. And the labor board said no. And there's a good discussion of when can the union amend. And that's the trouble too. You don't know 100% when you're going in there on the 5th day what they're going to argue. And they may say, well, yeah, we don't like it. We've now got the IRO report. We're going to switch it. And they may be able to make it a substantive amendment. The one thing that's really important is the substantive amendment, if they allow it, it's discretionary, has to be triggered from the date that the order from the board is made. And in this case, that was done. They allowed the amendment. That's the good news. The bad news is those cards are stale data because they're beyond 6 months. So what the labor board said to help the unions, unions, if you come and you've got a possibility because you don't know, file both of them. File the section 18, which is the individual one unit, or file a 142 variance, and just sort of choose when you get there. And then the time runs from the application being filed. And then the Norcon case is just one that I won't go into detail, but there were 3 people. One of them worked 30% of the time in the bargaining unit, which I thought was pretty substantial. The other ones, like with the reception, would come in and do some of the warehouse 5% of the time. And what the board said, no, that's not enough functional integration to destroy the bargaining unit application. What I thought was interesting was they said, we understand that in a small operation, because many of my clients are small and medium-sized businesses, and they said we recognize that you're gonna have somebody that's there 30 years. Of course, they can go in and they just know how to do it, but that's not the normal interchange, regular interchange that we're going to accept. So Chris and I will be asking a whole bunch of things in very short order, and we need evidence. What about part-timers? Do you have part-timers? Well, what about casuals? Not all casuals are included. Not all part-timers are excluded. The funny thing is, we don't know whether we want to balloon the unit because we don't know how those part-timers are going to vote, or do we want to, narrow the unit? But those are the strategy things we talk about. Managerial exclusions, supervisors. The labor code excludes from the definition of employees those that are managers. And there's a whole bunch of litigation. It's a very narrow exception. People think, it's manager, I call them a manager, so that's no big deal. It's a big deal, very hard. And so again, those are things that if you're looking down the road, and I'm not saying everybody go out and run and make all the changes, but just think about if you were wanting that manager to be in the unit or out, could you make some changes that are legitimate, that satisfy the board's criteria? And then, as I pointed out, it's always a question Chris and I have is, well, do we want them in or out? I don't know how we voted, right? So, or would vote. So confidential exclusion, very limited exclusion. The accountants and stuff you would think would always be excluded under that. They're not. But it's another exclusion. They're not employees for the purposes of the code. Employees on sick leave and LTD. Again, the question is, do they have a sufficient continuing interest in the bargaining unit? Nice lawyer speak. And each case is decided on its own facts, yada, yada, yada. And just like, Chris talked about the frustration of contract when you're dealing with your non-union people and they're out for a long time. Can you say, well, just due to the affliction of time and the fact there's no reasonable prospect you're going to return to work, is your employment just come to an end, right? That's frustration of contract. Similarly, we look at those type of things. So that's why we're asking the question. So we need somebody that knows the answers because you don't have a lot of time to. Familial employees, which is an outrageous exclusion contrary to the Human Rights Code, but I lost arguing that a couple of times. But in certain circumstances, family members can be excluded. Work permits employees. Chris and I have had some recent cases, whether or not they be in or out. I mean, think about it. Come on, how can a work employee, work permit employee from another country that's here for a short time, how can they be in? Well, the labor board will often include them. And then laid off employees, very limited test if you've got somebody laid off, because usually it's the employer trying to balloon the unit. They were trying to get them in, kind of hard to do. There's got to be real clear, I'm recalling you and you've got a history and, seasonal employees, et cetera. Independent contractors. How many people here say, oh yeah, I got contractors, right? And in fact, when you're talking wrongful dismissal law, we say, well, they may be an employee, but they certainly may be a dependent contractor, and they're going to be treated like an employee, right? The labor code defines dependent contractor. So you've got the big truck drivers, Jack Seawee, I acted for him when all the truck drivers were operating. They own their big $200,000 trucks and their own businesses, but they have the right to collective bargaining if they got over the threshold. And then finally, I know some people that are in the construction business, there are some unique aspects of the labor code that we'll be asking if it's a construction application. For example, there's a case called BAT Construction that sort of says, construction companies hire a bunch of people and then they let go, and then they hire a bunch of people and then they let go. So we need to get people that show a connection to the company in a way that's meaningful. And so BAT says they have to have been employed 30 days before the application, and they have to be have a reasonable expectation of returning to work within 30 days. So again, unions know that rule, so you can imagine how they play with it. The other thing is if you're unionized and another union comes in like CLAC, which a lot of construction companies love, and they want to take over, they can do that, but they're now restricted to making an application in July or August. And you can see why. The Labor Board in the latest changes said, look, if we allow a raid to happen in November when it's pouring rain, and you really low in your employees, that won't work. But in the summertime, we can expect it. So you can see how it's a real policy-driven labor code, and the application of the labor code is also policy-driven. We talked about unfair labor practices, and again, we just don't have time in this short period here, but just to alert you to be a little bit careful. What you say may come back to haunt you. If you go and say, did you join the union? Are you part of the union? And did you sign the union member? A, they're going to lie, so right off the bat, don't bother. And B, that may be an unfair labor practice if you then terminate that employee or you discipline or whatever, right? So you got to be careful what you say. The changes to the labor code, talked about unfair labor practice. Section 6 deals with, first of all, interference with the union, 6.1. And 6.3 deals with all of these things where you terminate somebody and one of the reasons is that they were union. Even if you got 9 good reasons, guy stole from you to do, but if the 10th reason is he's a union guy, right, you're going to get dinged. It's a tainted theory, which is a real problem. Under Section 14, the employer carries in the discharge the onus of proving that he was innocent and didn't have unfair labor practice mentality. One of the things that I put at the bottom, I should say Section 8 was the freedom of speech for the employer that protected employer free speech. 1992, take a look at 2025, same language. They got rid of the Liberals' change in 2002 that allowed much more leeway. So we're back to what was happening in 92, and it's much more narrow than what you would think. This is a free country. We should be able to speak. This is a huge decision for me. Union, you could have been out there, lying to them and, doing all of the things that should be an unfair labor practice, and we don't get the benefit of a vote. And you're telling me if I hear that there's union organizing, I got to be careful about what I say? That's the change that was made. I put in the Amazon case. It's unbelievable. Like unions are getting really gutsy. This is a huge case, and now they've got a big fight with Amazon because what Amazon did was the union applied. They didn't have enough that they thought was the right unit, so they withdrew that, and then they bought another one. In the meantime, back at the ranch, Amazon hires everybody but their uncle, and they balloon the bargaining unit. And so the union sort of says, "Oh, we thought there were 100, now there's 200." The labor board said, by the fact that you padded the payroll, that itself was an unfair labor practice, and we automatically certified Amazon. So, game on, because guess where Amazon's going? Up to the highest court in the land. But I think they're going to lose. Or they'll do like they did in Quebec, that is shut down, which is also the big problem, okay? What about new groups? And I said, some of you that are unionized, you should be thinking that maybe your non-union people could be drawn in. And if a union does that, and it's a second a second bargaining unit, the labor board's going to say, wait, we don't want a proliferation of bargaining units. We don't want a whole bunch of different unions and stuff. You can't run your business. And this is when industrial stability comes into play. Okay, and so the labor board says, okay, you can certify those people and add them to the current bargaining unit. And the tricky thing is if you've got a collective agreement and you vary in, they're covered by it. The leading case is the Arbutus Club, where the swimming instructors were varied in to the collective agreement. Well, the collective agreement didn't contemplate them, so a whole bunch of things emanated out of that. But whereas a certification doesn't give the union anything other than the right to bargain. It doesn't give them a collective agreement, doesn't give them anything. A 142 could give them a collective agreement, which you can see is a pretty easy thing to sell. By the way, folks, if you get here, look at the guy over there making, the truck driver making X dollars, and you're in the office, why don't you sort of come on over? The couple of cases I've cited there that I won't go into. But those are the type of kind of questions that Chris and I and others are trying to ask and answer within 5 days. And so it's difficult to move, but if you thought about it, we are successful in some cases, certainly in the exclusions. Those are pretty cookie cutter, and we can figure out very quickly, because we go through everything. We ask all these questions. Oh yeah, I forgot about him. Yeah, he's on WCB. No problem. He's in the thing. Put him in the list, right? So I wanted to talk briefly about, of all the stuff that the NDP did, I think this is the craziest thing in the world. Remember I mentioned that some of you that really don't think you've got anything to do with unions may have something to do with unions, because that certification and collective agreement may sort of attach to your business without you having any employees. And so what the labor board was worried about was that what happens when they retender, right, contracts. And this emanated out of HSA and back in 2002, et cetera, when the Liberals started to retender a number of these food contracts in the hospitals and that type of thing. And so what the labor code changed, they said, okay, successorship is when, if I buy a business in whole or in part, okay, and it's unionized, I'm going to be bound by all the proceedings at the labor board and a collective agreement as if I had signed it, right? So I buy a unionized operation, and so you get some questions about, am I a successor? Did I actually buy the business, right? If I buy 100 taxi cars, but I'm just using them for something else, I'm not in the taxi business, so maybe there's not a transfer of a business. There has to be a transfer of a business, okay? And so I acted for a number of Handy Darts, for example, where BC Transit would contract out to Handy Dart, a society, and would say, you know, you do that, it's our function, but you do it. And then they would put that contract up for tender, and somebody else would come in. And the labor board said, quite correctly, well, there's no transfer of a business, so we can't order this new employer to be a successor. So the new employer can be non-union, right? And so section 35 2.2 says, if you switch certain contractors, and if they are unionized, or they're in the process of applying for union status, you're bound by it. The new contractor coming in. It's very limited in the sense that it only applies to cleaning, security, bus transport, food services, non-political services in the health sector, right? And so here's how it kind of works. If you look at the section, it says the contractor, so this would be the new landscaping contractor that you got, okay? The contractor is bound by all proceedings under this code before the date of the contract for services entered into by the contractor, right? So I have a security company and I give them notice that September 30th, you're finished. And on September 1st, I sign a contract with you that starts October 1st. Pretty straightforward. Looks to me like anything that happens after September 1st, I'm not bound by, right? Because I've entered the contract, right? Good argument, bad place to make it, because the labor board said, no, the contract starts when you actually start the work, which is insane. and it's contrary to the language, right? Because you think about it. If I can't enter the contract until we're actually starting the work, that's ridiculous. That's not a business model. And the language seems pretty clear. And where the problem is, if you give notice to your current contractor and they terminate the employees, but they've got a window, guess where they go? They go to the labor board to be certified. Right? And so it is so contrary, I think, it's creating certification instead of it being for employees. It's certified to your business. It's like crazy glue to your business. And we're going to see some cases down the road about how you get out of it. The successorship operates by matter of law. The minute the transfer takes place, the minute the contract starts, it's automatic. Even though they make an application later, it's effective from the date. You can't argue that the union was delayed in bringing it. That was sufficient because the board says no. So they're very broad. The food services one, there's Sky Chef, I think it is, that out of the airport was bringing food and you know, just driving the trucks or whatever. And the labor board said, well, food services, that's pretty big. You got to get the food there and you got to, right? So they automatically turned them into, when there was a switch of the contractor. The new contractor was bound. So hope springs eternal. You can get out, but it's your employees that have to make the application. And so under Section 33, that's the normal one, where you've got one certification. If the employees sign up, what's really interesting, the labor board or the NDP said, well, we don't want to give employees who want to decertify the same rights we give unions. That is to say, you can do it just simply by signing a card. No, we got to have a vote. Right? So all of the nastiness of votes the unions complain about doesn't apply. What's good for the goose is not good for the gander when your employees want to get out, which again is kind of offensive, I think. But in any event, very technical about what employees have to put in the application if they make a mistake on the cards or something. I mean, Chris and I have been involved in a couple of these big ones, and it's really crazy how the board looks at it. So they take a very strict view of that. 142 is where there's a partial decertification. I've got a case that's coming up where when the union was certified, there were 5 kind of locations, the Vancouver Island, Vancouver, Kelowna, and other ones, and fairly distinct things. I argued that there had to be 5 separate certifications. The labor board said, no. I said, but at least give me the certification that says employees in the Prince George operation, employees in the, because my argument, thinking down the road, because we did have one group in Kelowna that was really against it, is that they may make it easier for me for them to apply under 142 and say, we want out, leave the rest of it, but we want out. We'll see where it goes. Again, labor board relying on a case called White Spot says, we don't really like to do this. So it's just harder to do, but it can be done. Okay, I know, when's the hook come? Pretty soon? So what can I do, Mike? Well, you can sit there and become unionized, and it's not all that bad. It's not good, but it's not all that bad. But ask yourself, and this is the classic. If I work for me, why would I unionize? And be honest about it, right? Get rid of the garbage can underneath the suggestion box. Nothing pisses people off more, excuse the French, than I asked the guy that, and I didn't get any. I got a snotty answer from that manager. Right? Where you're going to get hammered a lot is your mid-managers or your senior managers that have got a gripe to, right? And you're the boss and the owner, and things are great, people like you, but this is now the roadblock. So you've got to manage your managers to make sure that they're listening and answering. Comply with the Employment Standards Act, Human Rights Code, WorkSafe, all of those things. Unions will often, in their leaflets that they're handing out, will say, are you getting this? And because somebody's told them that they don't have their human rights or their employment standards, and they'll use that against you. We can prevent that happening. Educate your supervisors and managers. Listen and watch for signs of organizing. Best thing in the world is union put something in print, and then you can respond to it. Check your benefits and compensation package. There's the chamber plans. I think Chris was mentioning that I think Chambers has a plan that is pretty good for small and medium-sized employers. So if you don't have a plan, at least think about that. It may be helpful to you. Beggars saying, check your competitor. If you got a competitor that's unionized, go to the labor board, go on their site, look at their collective agreement, pick the things that the union's going to use to sell, things you could live with, but get rid of all the other garbage. Communicate both good and bad news. If employees can accept a lot of bad news as long as they feel that they're honestly getting it. Yeah, tariffs are hurting us, but we're going to deal with it, right? It's the old, they're hurting us, but this is what we're going to do. We're proactive. We're doing this, right? That type of thing. Employee committees are often used. Update material that you may need, employee lists. Now, here's a big deal. If you've got employee lists, contact lists, keep them confidential, because you can see what a union does. It gets an employee list. Instead of actually, meeting with them or whatever, they just get on their website or their email or know where their homes are and stuff. So it's amazing how many people have a really detailed, confidential information contact list that's floating around for everybody. So be careful on that. Written employment agreements, see Chris about those. Policy manual, see Chris about those. Hiring skills, we did a seminar and we're going to do another one again because I think it's the most important seminar we do, maybe next to this one, about how to hire, right? It's the most important step you make. The rest is you can fill in the blanks. And so be careful on that. Check references and the rest of it. If you're buying a restaurant or a franchise or expanding yours, be careful on that. Best advice, get your information ready if the union applies. See what options you have, et cetera. And finally, sort of keep Chris's phone number, my phone number in some sort of contact list if it should happen. And, we're there to help if we can. If you have some questions leading up to it, if you've got a sense, most employers have a sense of what's going to happen. And so maybe go with your gut and say, let me just see, remind me again what we're doing here. Finally, the section, I don't know, where's section 3? The section 3 report came out August 31st, 2024. A group that we're part of from the business community, a number of the Chamber and the BC Business Council, so we put together a response to it. I don't know what's going to come out of it. The Minister of Labor is trying to hide. She's not wanting to do any of this stuff because it's really going to be controversial when the economy is in tough shape. But one of the things is Bill 9 came out, which allows provincial workers to honor a federal picket line, which is crazy. And again, Harry Baines just issued it, banged it through. There was no consultation. And so it was out of the C-SPAN dispute. So you can imagine your employees are going to honor a picket line. It used to be they could only honor a picket line that's a provincial employer. And that would allow you as an employer to go and get relief, common site picketing. But now you can't get that. So it's what we really need, right? More labor disruption, more people not working, not really what you need. Big thing is, of course, we want the secret ballot vote restored. The unions are wanting to get access to employee lists in advance. We want to fight that. They want to do a whole bunch of an industrial inquiry into sectoral bargaining, which would apply more to your kind of restaurants and stuff. So like all, fast food restaurants in Burnaby are the automatic certification. So if they're certified, they're automatically covered by that. So we've been fighting that, and it's been pretty successful. They want to add to all that list I gave you for successorships and contracts. They want to add everybody. So whoever you're contracting with could be bound. And so generally, we're waiting to see what happens. My view is that the current minister does not want to go there. So I suspect it'll be kind of, if there is any changes, they'll be kind of neutral. But we're definitely, if you're an employer and you want to see changes, I think you got to figure out how to get the Conservatives back in. because this is a disaster. I heard a guy on the radio this morning dumping all over Rustad, who, you know, they want another review and stuff. And I just sort of say, you know, EB is very happy about that set of circumstances because it would be impossible to get in. And that's really the only way you're going to ultimately balance what's going on. So that's it. Any questions?
So successorship, I'm a little bit confused on. Does that mean the people I hire to clean our office, their union, and I decide I'm no longer happy with them after a couple of years, I'm not cleaning stuff anymore, I have to hire another union?
No, if you've got a union that's got a collective agreement covering those employees,
Okay.
and you want to get rid of them, you've got a very, very high bar because the labor code says every collective agreement must have a provision that says you can only terminate for just cause, which is a very high standard. Unlike the non-union where you can just sort of pay them out of severance, you can't do that in a union thing.
Okay.
Right? So the collective agreement will say you gotta, like even somebody steals from you, union will bring a grievance and arbitrators, well, you know, let's give them a warning. So,
Mike, I think what she's saying, they contract the cleaning
oh, sorry.
company that's
Contract
unionized.
for 3
Totally
years, yeah.
Yeah, so your business is now, quote, unionized. So if you contract the cleaning to the ABC companies unionized, and, you know, you want to retender that contract because they're not doing a good job, you got all the great reasons in the world that often people have, right? You bring it to an end, give them notice 30 days from now. You're bringing in the XYZ company, which is non-union, and the union of your current contractor. Union comes in, organizes those people before the contract is finished. New guy comes in, he steps in the shoes of the previous guy. Isn't that crazy? That's
How would I even know if my current cleaners are?
you know, and even if you know, well, the one Chris and I had for a school where they had the cleaning people, and the school gave the current contractor 30 days notice, and that current contractor was not unionized, right? And the one they were bringing in was not unionized. Nobody raised the question, right? The minute the 30 days was up, the current employer gave notice to his employees. Sorry, guys, I'm out of here in 30 days. Your employment is terminated in 30 days because he's obligated to do that, right? The minute that happened, the union ran to, or the employees ran to a union, and the union applied for certification and got certified before the contract was turned over to the new guy. And so Chris and I were able to figure out how to, I think we just threw up so much stuff against the wall that they actually literally walked away. The union said, no, that's fine. But, you know, that's rare. I mean, if there's and so, yeah, we're continuing to try to find ways to get around it. I always thought that the language of the section really gave you the protection, right? If you're bound by the union at the time you sign the contract, right, you can at least check it out. You can make adjustments. But if you sign the contract on September 1st, that starts September 30th, in the meantime, your current contractor could be unionized and you're bound by it. So you can't even get out of it. Lots of stuff.
I understand everybody has slides, so I may go quickly through some of the slides because some of them are background that you probably are familiar with, or some of it's already been discussed, by Chris, in particular, the WorkSafe BC stuff. Okay. And Bonnie's joining me. She's going to do just a few minutes at the end of my presentation on trends in workplace investigations, and you'll understand why the segue based on some of my discussion of policies that I recommend everyone have. So here's what I see as the trends from this year. Minimum wage has gone up. You're probably already familiar with this. You're probably also familiar with the paid sick leave, the 5 days that everyone now gets once per calendar year. You also probably have heard, and this is all very recent, the getting rid of doctor's notes. It was announced earlier this year, and then the rules just last week came into force, so I'll just briefly discuss those. And of course, there's the increasing awareness, there's the increasing awareness, we may have a battery dying on this one, of psychological health. You've heard the increasing awareness of psychological health from the WorkSafe BC perspective from Chris. Also, one of the things we've seen a lot this year in 2025 is discussions about political discourse in and out of the workplace. So I'll briefly touch on that as well. The minimum wage, as you're probably aware, has been going up pretty regularly. And part of that is because in 2024, they tied the increases to the BC All Items Consumer Price Index. So it will go up along with that to the nearest 5 cents. So just so you have a bit of a sense of that. So I'm going to go very briefly over this. You're going to hear more about human rights law later and kind of the latest case law updates. But the reason I put this here, and you'll see the next slide talks about WorkSafe BC a little bit as well, is because these are the legal obligations that your policies are helping you to meet. So I've given you some examples here of what is prohibited conduct under the Human Rights Code. Mike made this comment earlier. He was primarily talking about the BC Labor Code. I too am also talking about primarily the BC kind of employment laws, human rights laws. We do work in the Canada Labor Code, Canada Human Rights Act sphere as well. So if you are a federally regulated business, please feel free to reach out to us. I have not gotten into that. They're similar but slightly different on a few fronts. For those of you who are already federally regulated industries, you probably know a little bit those differences. Vicarious liability is an issue and why I recommend policies. What that means is if you as the employer have an employee who's gone rogue and done bad stuff, you still may be on the hook for that. That's that vicarious liability piece. So that's why, again, introducing policies, updating policies regularly, having your employees kind of regularly checking in and being knowledgeable about where your policies are, help you prove that you've done your best. And really that bad actor, that bad employee you've got who's been asking everybody on a date when everybody's saying no to them, you've kind of got your defense ready there. So I'm not sure if you'll be able to read this as the slide up there, but this is a good example of what not to do in the workplace. So this is a workplace where there's a lack of psychological safety. Another example of lack of psychological safety in the workplace would be somebody who's micromanaging. So a bit like what Mike said, you got to know your kind of middle managers. Sometimes this is those people, they're micromanaging. So you heard earlier about prohibited action complaints. This is one of those examples. Somebody's raised a health and safety issue. In this case, it was harassment, sexual harassment, and then they were fired for it. So this may not end up in the realm of WorkSafe BC unless there is also a bullying and harassment claim and a mental health injury claim kind of being claimed, but it definitely will end up in the BC Human Rights Tribunal. So this is where, if this sort of thing happens, you're in trouble. Come and talk to us. So what we're trying to do here is definitely avoid all this. So I'm a big fan of workplace policies because it helps to communicate your common values and your ethics in your workplace. You want to make sure that everybody's being treated fairly, so it speaks to that as well. And it also provides some certainty and consistency. And I appreciate I'm probably talking a bit quickly because I appreciate my time's a little bit shorter. And most importantly, it creates your compliance with your legal obligations. I definitely recommend a number of policies. I'm going to speak just about a few of them here, not about all of them. The respect in the workplace policy, that's really where understanding that discrimination is not allowed, that sexual harassment is not allowed, bullying and harassment is not going to be tolerated. That's what you put there. Your leave policies. So this has to at least meet the Employment Standards Act minimums for leaves, which I'll mention very briefly in a moment. But you can always offer more. And to be honest, if you want to keep your employees and not have them unionized, one of the things to do is be more generous than what the Employment Standard Act minimums are. Social media policies. This means about not just use in your workplace, but really like how people present and what they say outside of the workplace. Privacy policies, I won't get too much into that today. There are a couple slides for you to review. And work from home and remote work, again, a couple of slides for you to look at. I won't talk in detail about that, but I will mention why that's important when I get to that slide. So respect in the workplace. Sometimes we call these, it's a little bit older term, like the anti-racism policy and that kind of thing. Really what it is, it's about making sure that everybody understands that your workplace is inclusive, values diversity. So regardless of what people's backgrounds are, they're all going to be treated the same way. You want to make sure that bullying and harassment is clearly defined in it, what that means and how it's not tolerated. WorkSafe BC does have some resources on this. They have a really, in my opinion, pretty simple definition. It's about, conduct that is humiliating to somebody, and then provides a bit what Chris had talked about, that management exception. You are allowed to direct your employees, and your managers are allowed to say, constructively, this needs to be done a different way, but they can't be doing it while yelling. They can't be doing it while making racist comments or bringing stereotypes into the whole thing, into the whole conversation. I also like really making it clear who the policies apply to as well. So it'll apply to your employees. You may have contractors who are in your office occasionally. It should apply to those people as well. If you've got clients that are coming in, or you just are dealing with the public, it should apply there as well. There may be different ways that it applies. So this is where if you want to bring your specific workplace to us, we can help work that out best for you. I do volunteer work, and so we have a respect at work workplace code of conduct that applies to us and to staff and to parents of the youth that we're supporting through my volunteer work. So leave policy. I'm going to kind of jump into this one pretty quickly because it is somewhat new. Having a leave policy, again, why we always have policies, everybody knows what's what. It's not a surprise when somebody asks for something and they don't get it, or somebody is on a certain kind of leave and some other employee is like, why is that person on the leave? Oh, look at the policy. You might understand it, because obviously you can't share personal information of your employees, but you can always point to the policy, say, if you're inquiring about leaves, here's the policy for that. I also will say, again, this goes to who are your managers, your supervisors, understanding their roles. Having a good policy also helps to make sure they're not overstepping, because especially when we get to these medical leaves, you can get in trouble for asking too much information. You're going to see this as reminders several times. Should be clear, needs to be known by everybody. So I recommend kind of yearly reviews by everyone, and it should be followed to be effective. So, don't cherry pick who you apply it to and when you use it. If you've got an HR team, they should be, looking at these all the time and making sure employees are bringing forward things as required by the policy. So let me explain a little bit kind of where we're at with leaves right now. So the Employment Standards Act provides a number of protected leaves. You've heard a little bit mentioned before by Chris that a new one is potentially being introduced. Right now, things like maternity and parental leave are under the Employment Standards Act, along with family responsibility leave, compassionate care leave, reservist leave. So if you've got somebody who happens to be an Army reservist or a Naval reservist or an Air Force reservist, and they want to go do a 4-month full-time tour somewhere, that is protected. Bereavement leave is also protected. It's a 3-day unpaid leave. And then jury duty. If somebody gets called for jury duty that works for you, you do have to give them leave on that. Obviously, there's some clear definitions in there. Most of these are unpaid leaves. However, let's get into these new sick leave kind of rules. So last year it was introduced, or even the year before, it was introduced that every employee in British Columbia gets now 5 paid days of sick leave. They also get 3 unpaid sick leaves. This is per calendar year, so you don't carry them over. They expire at the end of the year. This can be taken any day after 90 days of employment. The new rules that came into play this month about medical notes relates to these 5 days. So if you have an employee that takes 5 days off in a row, they get those 5 paid days, you can't ask for a medical note. Basically, medical notes were overburdening our medical system. And so that sort of kind of like 5 days, don't ask for a note. You are allowed to ask for a note if that employee takes 2 health-related leaves within the same calendar year of 5 consecutive days or less. So kind of if you've got somebody who's sick in January for 5 days, sick in June for 5 days, that's at the end of that second one, that's when you're allowed to start kind of asking for notes. I think we're going to still see a bit more clarification and like understanding in the going forward. My recommendation is maybe get some legal advice about the circumstance. I'll be honest, I sometimes advise employers, you know, is this the time to ask it? Sometimes you get them preemptively and they're pretty basic. Is it the right time to ask for more information even after 5 days? Probably not. It depends on what kind of workplace you have and what circumstances of information you've got. You are allowed to ask after that period of time for the reasonably sufficient proof is what they call it. And it means documentation as simple as receipts from a drugstore or pharmacy, a medical bracelet. So if there'd been, for instance, you know, a car crash that took them out for a couple of days with a concussion and they were admitted to the hospital, even if it was just at the ER or at a urgent care, that medical bracelet might be enough, or some sort of signed confirmation from the employee stating that they are sick. So not quite an affidavit per se, but something that you can kind of help us understand is truthful.
Can I ask, is it only after 5 consecutive days? So let's just say we've got an employee that calls in sick every single Friday. Or every other Friday, you're never allowed to ask for help?
So the language right now in these rules that just came in is 2 health-related leaves of 5 consecutive days or less in the same calendar year. So is that somewhat open to interpretation that if you get to the 10 days by March 15th, maybe, yeah, you can inquire? Yes, I think we're going to still see some back and forth about that. But technically, yeah, like if you got to 15 days and it was March 15th, yeah. That may change when these new rules come in about the 27 weeks of protected leave. Now, just to remind everybody, protected leave, what does that mean under the Employment Standards Act? It is a leave where you must return that employee to their job when they're back from their leave. So maternity leave, you've got to bring somebody back to the job that they had before they took their maternity leave. Parental leave is the same. This new 27 weeks of sick leave that is being proposed would be the same. And it could be that you've given an ROE and they're accepting EI benefits, medical benefits during that period of time. So you're kind of like bringing them back there. So this is where some of the human rights law comes in as well, because you also have a duty to accommodate somebody who's, been off work for medical reasons. And depending on what's going on, that's where you can, again, ask some information about that return to work process. So some overlapping issues. I'm probably speeding through it a little bit. I appreciate.
I just had a question about like part-time employees who work shifts and things like that. If they don't request sick leave, you're not required to give them or sick pay. Like you don't have to give them, like say they work a 5-hour shift in the evening and they're calling sick. We're not required to pay them sick leave unless they request sick leave or sick pay.
So the idea of the sick leave or sick pay, yes, you've requested it because somebody's off.
Yeah.
Are you kind of saying that they're sick between their shifts or during their shift?
Like we work with younger staff that work a few times a week kind of thing. And so sometimes they might call in and they're like, I'm not feeling well, I'm throwing up today. And we have to find them a replacement in the nature of our business. But if they don't request, we end up paying someone else because they're not there. But we don't have to pay them sick pay unless they are saying, can I be paid for today?
I have not encountered that question, so I will have to defer and get back to you on that
We
one.
don't generally because somebody else is replacing them that day essentially. So
Yeah.
they always have to have a substitute in our business, so somebody else is paid. But we did have someone recently ask for sick pay that was a part-time employee, and so she had requested that. But I just wonder about that in general.
So the part-time employees are eligible for it, and it's just when you pay somebody to replace them, that's what I'm not sure of. So let me get back to you. And it could be one of my colleagues actually knows the answer.
In our policy, it's clearly stated, if you're sick, you must submit an absence request to the board. So it depends on what you have, sometimes they know that they have to apply. So our policy clearly states, you have to inform the supervisor and then apply for any leave through the portal. So if they don't do that, then it's onus is up there.
They just lose that.
Yeah.
And again, I think that speaks to why having a policy to explain a bit of that, because you shouldn't be penalized as the employer for paying two people on the same day. So I'll just have to look into that one because that's not one I've encountered.
Sorry, just a quick question, because the protected leave for sick leave covers, the 5 paid and 3 unpaid, so 8 days in total. But the lack of, the not being able to ask for a sick note or any other kind of proof is 10 days.
That's one of the changes.
So if you have an employee that's taking, their 5 paid sick days in the year, and now they start their second week, later on in the year, they get sick again. And, they use up their 3 unpaid days. Now the protected leave portion has kind of run out. What happens at that point? Because we can't ask for proof that they're still sick at that point, at that not 8-day mark. But they're saying they can't come back to work.
So I think this is where we have to be careful about what's protected leave, because we don't have a protected medical leave right now in BC. That's what's being proposed.
The mandated.
Yeah. So everybody's eligible for 5 paid sick days and then 3 unpaid sick days. If for any reason they are not able to work and they are an employee who doesn't fall under, a salary and other policies about leaves, then they would be unpaid unpaid workers. So that's again where you sometimes want to have a policy that speaks to that. So it's clear to everybody that if you are sick after these 8 days, it's not a protected leave, because those 3 days are currently protected. And until those new policies come in about the 27 weeks, it's not technically a protected leave. Now, I am dealing with a client right now that there was a sick leave policy, and it was very onerous to get it to apply, but it did. So, this was for more than the 5 days and the 3 days. And they threatened to treat the client as having left employment because it was an unproved unpaid leave. So I think there's some things to have in a policy that speak to that. But yes, it would technically be until this 27 weeks becomes something in the Employment Standards Act as a protected leave. Technically, it could be just an unpaid leave. Do I recommend terminating somebody after 5 days of unpaid protected leave?
I think
Yeah,
it's,
maybe not, but
more of like an employee, they're sick, they're not checking their emails, they're maybe not checking their work phones. Work's trying to call in and check on them, and they're kind of gone AWOL.
and
And again, we can't ask for medical proof about why they're still off, but they're not answering their phones anymore or whatever, because they're in bed dying at us. But
yeah, and I think this is where having policies about bullying and harassment are key, as well as obviously these, because it could be actually something else is going on that they now don't want to talk to anybody because nobody's listened to them about a bullying and harassment complaint. So I think if you truly are having somebody go AWOL, it's been 15 days, they haven't been at work, then yes, you are starting to get a situation where it does look like they've abandoned their job. So it's not a contract frustration issue like what came up earlier. It's potentially them abandoning their job. There's nuances that should definitely come to a lawyer on that, because we don't want you to get a claim of wrongful dismissal because you didn't check the right places. And yes, maybe they left all of their phone and work stuff at work because work was the stressor that is taking them off work. So you just want to tread with that one carefully. But it would be potentially abandonment of their job.
One more question, sorry.
Yeah.
What we've been doing is asking for, we have a very physical workplace, right? So we've been asking for, let's say, 3 to 5 days. It's a serious illness. Let's say they hurt their shoulder. It's not a work safe BC thing. They did it separately. We've been asking for a doctor's note to say they're okay to come back to work. So can we no longer do that?
So the fitness for duty kind of medical notes, those are a bit different and don't fall under this. This is like when people can't be working. Returning to work and understanding limitations, that's more cutting into the human rights duty to accommodate. I'd be cautious about doing it until that person is like not working again for 15 days. I'm giving 15 days as a bit of a random time because it's more than those 10. It could be that it is the 11th day based on the circumstances.
Make sure they're okay to come back to work physically. That's why
Yeah.
we asked for that doctor's note, but it seems like we have to self attest now versus.
Yeah, and I will say that the fitness to return to work can be a double-edged sword because you've got a duty to inquire as an employer. You are inquiring, so that's good. So it's good that you're doing that. Sometimes, though, that will get misinterpreted as you are trying to push them out of the workplace. So this is where it can be, depending on how the employer, the employee is, your relationship with that employer, it may be fine. And I don't think it's wrong to ask for that kind of letter at the right time. Too soon or in a already sort of fractious relationship may tip you over to you're pushing me to come back to work. Yeah.
Well, actually, they want to come back to work. in most
Yeah,
cases,
okay.
but we're like, whoa, hang on.
Yeah. Okay.
Are you
So that's
ready?
great. Yeah. And that's where, like, we know that you had this injury because you've told us about this injury. Can you please tell us if there's any restrictions or limitations? I think that's where you start taking it into kind of what your duty to accommodate is. You're inquiring about the injury. You're trying to accommodate any limitations that might exist because of that injury. So you're bringing it more into kind of the human rights duty to accommodate kind of realm, in my opinion. I appreciate I've kind of talked over a whole bunch of topics there.
What kind of proof can you ask for if your employee still has their sick days available, but they've previously asked for, say, a Friday off because they wanted to go to a concert? You weren't able to give it to them, and now they've called in sick the day of the concert.
Regrettably, if it's just that first, paid sick day, nothing. Regrettably. If it was the 20th sick day and they didn't have any paid anymore, maybe you could ask for this reasonably sufficient proof because you've now hit that threshold days. Yeah. Yeah. I want to quickly just move on to the social media. I appreciate we've got kind of about 5 minutes and you want to for lunch. We may go a little bit. What I may do, if that's all right with everybody, we will have another Q&A period that's longer at the end of our afternoon sessions. So feel free to ask questions during that period of time. Social media, what I think is important just to flag very quickly here, because I do want to give Bonnie a chance to tell trends. And this is actually a very good segue to that. Social media policies is about your employees, their conduct, and how it's kind of maybe coming back and blowing back onto your company. Not everything that happens in social media by an employee should be cause for concern. You might need a, investigator to look at this. It's important because we do have people who are allowed to engage, and I mentioned the political discourse earlier, allowed to have opinions that may or may not be yours, may or may not be the company's policies. However, they are allowed to exercise that political discourse kind of political beliefs, share their political beliefs, as we would call it under the Human Rights Code, without fear of repercussions to their work, unless the conduct is such that it is impacting you as an employer. It's damaging your reputation because of the nature of the person who's doing this, who's kind of got these political beliefs. It's not about the beliefs, it's about how the conduct is impacting your employer. So there was a case earlier this year that you may be aware of. Sorry, it was late last year, so about a year ago. The Northern Health Authority fired a senior staff member for things that, and a particular lapel that she was wearing in off-duty hobbies that she had, specifically a choir. From what the media has reported about this, the senior staff member was expressing her political beliefs outside of work, and non-employees then reported to Northern Health Authority about their concerns about those political beliefs. According to the Northern Health Authority, the senior staff's unique role in the organization, they actually were holding a role that involved diversity and inclusivity kind of initiatives, meant that the fact that there was a political belief being shared that was of one view was problematic, because that could then exclude people coming to her in this role that she had if they did not share that same political belief. So that's where they took the position they had every right to terminate her. It is still going through the courts. She has argued wrongful dismissal. I think we'll see how that goes. As I mentioned, what you want to do when you're looking at your social media policies, because there's been other missteps. The Vancouver Library kind of took some positions earlier this year that kind of got them into trouble. You want to focus on the conduct and not the beliefs, or not the statements that were made. It's like, is this conduct, truly impacting our workplace? And to be honest, you may have employees that it doesn't matter, like what they say, like it's not connected to your workplace. You've got some slides about privacy law. So I'm just gonna slide through, and you've also got some slides about workplace remote work. The reason remote work is important to look at is because WorkSafe BC has rules about what is in the course of employment. And if you've got remote workers and they're not in BC, for instance, for periods of time, their remote work is somewhere other than BC, that can be a problem, as well as if they're hurt in their home office outside of home office hours. So there's some things there to discuss. I'm sorry to go so quickly over that. I'm going to pass it off to Bonnie. Workplace investigations, I didn't mention it too much in the initial discussion about respect of the workplace policies, but one of the things I think is really important, make sure that your policy includes how to investigate, so that, again, everybody understands what their role will be. Do they have to participate if they're a complainant, a respondent, a witness? And also, I really like to speak sometimes about bystander, their role in your workplace policies. If you've got somebody who's witnessed something but isn't sure what to do, and how your supervisors are key. So I'm sorry, I've just crammed a whole bunch in there very quickly.
Thanks, Hannah. If everyone can bear with me, I'll go as quick as I can so we can get to lunch. But I've just noticed a trend in my practice this past year. And then I attended a CBA subsection meeting, and it was exactly the topic I've been noticing. So I thought it was worth sharing with everybody a little bit of what we've been seeing. And basically, it's that as I guess the proliferation of workplace investigations continues to grow, we're seeing high stakes, we're seeing really senior employers that are sometimes dealing with this for the first time under policy that's been newly drawn in all sorts of situations. And whether you're the complainant or the respondent, often you really want some help because it's a really emotionally taxing, draining, complex, high stakes situation. So I put up on my first slide here one of my favorite Dr. Seuss quotes, because I feel that by being the person who is in the room assisting, whether it's the complainant or the respondent, I feel like having that second set of eyes has been really useful to kind of get the emotion out ahead of time so that the story can be really thoroughly explained from their point of view. I'll just move to the next slide. Thanks. So I've already mentioned it's really lots of pressure, high stakes. Again, the support is useful because the timeline is anybody's business. Sometimes you're waiting on witnesses. Sometimes somebody's not available. When it's an external investigator, they're a stranger. You're kind of having to share some really sensitive information on the spot or respond to sensitive information. There's going to be, at the end of the day, an assessment on credibility. One of the parties is going to be held, whether it's 51% or 49%, to be the one that's more credible in this situation. So it's a very sensitive time. So where possible, these types of supports are really useful. So regarding a few quick notes on regulatory investigations and unions, if you're dealing with union, really wise to get ahead and read the CBA, the enterprise agreement, see what that says about these types of processes. Typically, a union member will be allowed to have a support person there. They don't have to be a lawyer, but lawyers who are trained in investigations, if it's really high stakes, a wise thing to do. With the regulatory investigations Fiona and I were discussing that we've had this year, their processes are pretty thorough and rigorous. They try to do their best and utmost to prove at every step that the procedural fairness has been taking place. There's chances to read transcripts of what's being said, to write submissions. So again, having a lawyer that might be able to assist you with that can be really useful. So I guess preparing parties for investigations, the anxiety really builds as the investigation's nearing because when the person doesn't know what to expect, it's like any of us, the fear of the unknown. And so often too, they'll have a lot of questions and they don't know if they can ask the investigator. So if they have someone that they can go through and ask them questions ahead of time, it might help them to quell the nerves. So things that we can do to help prepare is obviously bring compassion, help normalize the process, go through what a typical investigation should look like and certain things that they can be mindful about. Pre-interview, trying to separate the emotion is really helpful there, and so that they can present their ideas clearly and succinctly. And then also to remind them, especially if it's an external investigator that doesn't necessarily speak the industry language, to be really clear and to build a chronology. So if you can go through it step by step and be clear about what happened, if you have different complaints, break them into the two subsets or more subsets, and just come in with as clear as the pictures you're painting, able to paint for someone who might not know what the acronyms are or what typically happens in that industry. And then help them to organize their documents, make sure that they've reviewed ahead of time any text, emails, WhatsApp chats, whatever it is that they have that kind of helps them to build that they might be able to provide to the investigator to help the investigator, again, better understand. When we're at the table, when the investigation is actually on, it's really great when a lawyer doesn't go in thinking it's time for court, because really you're just there to allow the person to tell their story. If you're interjecting and making all sorts of noise, you're really probably actually causing more damage than helping the situation. And so just ensure that they've gone through everything. If they've missed something that's important that you know, maybe remind them, oh, remember what you said about Miss Smith, you might want to go over that. And then, oh yeah, I completely forgot, you're right. So Miss Smith is my neighbor, blah, blah, blah. And it just helps them to kind of get everything across thoroughly so that the investigator can then do their job. And so a couple quick examples, I mean, I can go over them. I've summarized them. There's really interesting things happening. Fiona just mentioned about social media. We've got someone who's an elected official who's now being, I would say, retaliated against, and they're investigating certain things that I believe in her duties. She's just saying, you know, as an elected official, things that she's looking at, and it's gone social. And there's just layers and intricacies, and it's really nice to be able to support people in these times that are fraught with so much pressure and complexity.
Hey, hi everyone. We're just going to get started with the next presentation now. So basically, as you can see from the screen, we're going to be talking about just cause for this presentation, or as some lawyers like to jokingly call it, just cuz. It's a really important distinction that you make sure that you're falling into the just cause category if you don't want to have to pay a whack load severance, basically. So if you take nothing else from this presentation, make sure that you're firing them for just cause and not just cuz. Now, basically, it's probably gets, so I understand that a lot of you will be familiar with the idea of just cause, especially for those of you who are in formal HR roles in your organizations. But that being said, it's not a bad idea to start off with a bit of a refresher on what is and is not just cause, and then we can go through some cases. So basically, one of the key things to understand about the concept of just cause is that it is referred to pretty frequently by the courts as the quote-unquote capital punishment of employment law. So if nothing else, that at least gives you perspective on how seriously organization, or rather the courts, will be taking it. And there's a really good policy reason for that. It's that essentially from the court's perspective, the rationale was that if they have too low of a threshold for what's considered cause, and you can land in situations where someone who's been at an organization for 30 plus years has made a mistake and suddenly is let go with no notice, no severance, because that's what just cause amounts to. It basically means that instead of having to pay the employee some severance, the organization pays them zero. So because of the fact that it's a all or nothing concept, that's why the courts look at it so differently than a lot of other situations. It also really should kind of reinforce the idea, as some of these cases that we'll go through will, that just cause, unlike a lot of other types of defenses, is one that is it's going to need relatively extreme facts in most cases. You're going to really need to have dotted your I's, crossed your T's, or had someone that's really made almost a newsworthy type of mistake in the workplace, or done something very intentionally. Essentially, the common thread through... Whoops. Oh, and this is how you guys know that at least the team is okay with IT issues and adapting on the fly. And of course, we totally scripted that. Yeah, so anyway, basically, as I was saying, the idea to keep in mind is that with just cause, the facts will really, really matter. You could basically have two cases that supposedly are similar in the sense that, for example, they're both about safety and a serious safety breach. But the thing is, those two cases could have different outcomes depending on other facts in the case and the overall context. So that's kind of the main point as far as that goes. Now, there's basically one relatively old 2001 leading case from the Supreme Court of Canada that essentially underpins the just cause analysis. So essentially, the idea is that the case more or less says that the court will take into account these three factors in determining whether or not just cause will exist. So the first one is basically the nature and extent of the conduct. So there are numerous cases saying that something like a safety violation is going to be looked at more seriously than some other forms of misconduct. So another good example is that if someone has stolen from the company, then that's going to be looked at differently again than someone who has, for example, just misfiled a expense report or misunderstood a policy or something. So basically the thing is that the starting question should virtually always be, how bad is this? You essentially want to be starting off ideally with lawyers involved, but even just internally, your first question when you're dealing with a potential cause termination should be, why does this matter? It should be, is this really that serious? And that then leads into the third element of the test, which is proportionality, where basically the thing is the court is going to be asking themselves not whether what this person did was serious. They're going to be also asking themselves, is the termination proportionate? In other words, the question eventually comes down to, was there a form of discipline that would have worked other than termination for cause? So what that means is that usually if it's a first offense, even for something like dishonesty in some cases, or showing up to work drunk or things like that, and the thing is, sometimes it's surprising because the thing is, we deal with situations sometimes where a lot of people, if you ask the average person, or even if you ask the average employee, they'll say, yeah, of course this person got fired. But the thing is, that's not the question. The court's question is going to be, could you have done something different to deal with this? And the issue that a lot of businesses will run into is that they will have stopped and made the decision before asking that final question. They basically will have said, okay, this person did something really bad, we're gonna get rid of them. The thing though is that before you get to that decision, ideally you should have been asking, okay, if we don't fire them, could we do something else? Could we issue a final written warning? Could we suspend them? Could we investigate? And of course, there's always going to be potential trade-offs and considerations and all kinds of lines that you can potentially run into in the course of, for example, investigating a situation. And if you have red flags going off, that's usually a pretty good cue to check in with us about how you should go about it. Sometimes this actually dovetails well into the question of, do you investigate a potential issue internally, or do you loop us in to give you advice on how to do the investigation, or do you potentially need to consider hiring an external investigator? So the thing is, in a lot of cases, the question of the whether the situation is going to amount to cause and whether it's going to be proportionate to terminate them is going to come down to is basically looking at the whole picture of their employment with the organization. So the idea is that if someone's been with the organization for a long time, or if they've had previous issues with, say, attendance or quality, and that has not been dealt with in the past because the HR role is new, then you're going to probably deal in a situation where you're not going to terminate them for cause, at least not yet. The idea is that one of the key questions that the court's going to be asking themselves is, in determining whether something's proportionate, is basically whether the person was given the sufficient opportunity to have corrected their behavior. So the thing is, this is not to say that you're always going to have to not terminate them until you've been given enough warnings. There are definitely cases where sometimes, even just from a business perspective, you have no choice. Sometimes someone can be a significant enough problem in the workplace, either due to morale or due to trust, that you just make the decision that you need to do it no matter what. But the thing is that the circumstances where that's going to amount to cause are relatively few, and the more that you're able to ask the right question at the front end and ideally get your ducks in a row at the front end, the better position we'll be if we need to defend a lawsuit based on that termination. Now, the next thing that we're going to cover is, is basically examples of what may be caused. So like I said, dishonesty, assault, really intentional insubordination, or major safety violations are examples of things that will be taken more seriously by the court. But the reason why I put may in all caps is because, believe it or not, there are cases where someone has touched someone without their consent, and that was not cause. There have been cases where someone has punched someone, and it's not cause. So the thing is, those extremes really illustrate how much of an uphill climb it is, and the reason why it's so important to make sure that we're positioning ourselves as well as we can before getting to that point. At the end of the day, sometimes decisions will happen before even HR knows, and we do the best that we can. But the more that we can have a paper trail as strong as possible, the more likely it is that we'll be able to actually have a strong defense against it.
Can I ask really quickly?
Yeah.
Can you give me an example of what a major safety infraction violation would equal just cause?
Yeah, so the question from the floor was basically an example of a major safety violation that would amount to cause. So the thing is, the crazy thing is that there's probably not a single example that would say every single time in every single case this would be cause, because again, yeah, exactly, context matters. Yeah. But basically, the thing is, that's a fair question, and I'd say that basically, if someone has been hurt or, God forbid, killed as a result of the safety violation, yeah, it's probably going to be looked at differently by the court. But the thing is, as some of the cases will show, basically the idea is that even when we're dealing with safety, and one of the cases we're going to go over is a train derailment case. So pretty serious, but even in that case, it was not caused. And the reason for that was because the safety policies and procedures were not sufficiently clear or sufficiently well known. So that's going to be one of the first questions that we would have if someone says, hey, we've had this safety breach, can we get rid of them? Then one of the first questions we're going to ask you is, okay, where's your policy? And did they sign this policy? Did this specific person know about this policy? So the other thing that we're going to go over next is basically some examples of cases where just cause was found. So the interesting trend, at least in these more recent cases, seems to be that where they involve cases of relatively extreme sort of breach of trust, I would say. The thing that's kind of notable, though, about the case of Mikhailchuk is that in that case, the dishonesty in question was essentially a dispute over a set of receipts. So in this particular case, one of the key facts was that the president of operations of the company, so very senior leadership, had submitted receipts for a dinner with his wife during a work trip that he had put the names of other employees on. So the thing is, frankly, I think that it's entirely possible that this outcome could have been different had he simply been honest about who was at the dinner, or even if he just put himself. The other thing that kind of played into this, though, was first the seniority of his role, but it was also because while he was being investigated for that conduct and confronted with that conduct, he refused to admit to the fact that he had done that and didn't apologize or anything. So the thing is that when you have someone who has basically the more that it looks to the court like someone has made a mistake that they can be redeemed for, the less likely it is that cause will hold up. At the same time, both this and the Vestergaard case are really good reminders of the fact that senior management will be held to a higher standard. And that's because they're often placed in a position of trust and a lot less oversight. That being said, even though there's that high standard placed on them, again, proportionality and context matters. So if someone lies about where they were during the weekend or where they went after work or why they showed up to work tired, that's probably not going to be considered cause. On the other hand, submitting receipts for personal dinners and saying that it was business dinners, yeah, it probably is going to be cause, especially if it's happened more than once. Now, the Vestergaard case was one that was kind of interesting too, because that one was one where there was also so there's basically two Destiny Media cases, and Vestergaard was one of the more recent ones. And it's interesting because this case was connected to the other one. And the basic background of it was basically that Vestergaard was the president and CEO of the company. So again, pretty much as high as it goes and held to a pretty different standard than the average employee will be. In this case, both this person as well as one of their subordinates were neglecting their duties to work on a separate business. So basically they weren't, not only were they spending company time on other stuff, but they were also like failing to actually perform their duties for the company that was paying them, Destiny. So that was one of the key facts that led to cause being substantiated. And then the other part of it, which was interesting, was the fact that another reason for the termination was also, again, the fact that basically it was pretty obvious that there wasn't a chance of redemption, because this person was given an ultimatum to cooperate with the workplace investigation, or else they would be fired for cause. So, and this was after, of course, the other issues had already come up, so there was a really good basis for that. So, and he refused. So basically the thing is, when you look at that case in the whole, you can see why the court would have leaned in the direction that they did, because taken as a whole, it's pretty obvious that it's someone who intentionally acted the way that they did and wasn't going to change. If, on the other hand, it was basically someone who had historically been moonlighting and hadn't really had issues, wasn't affecting the performance of their role, and hadn't been told that they should stop doing it, that's probably not going to be cause. So for Shellington and Mercer, that one was an interesting case, which, so basically the thing is, the key lesson from that case is basically just that if an employee is making a bunch of secret recordings during workplace meetings, including just regular conversations with their coworkers, and we're talking about 50 plus recordings, then yeah, that's probably going to be cause. But the key thing to keep in mind is that you don't want to overestimate the importance of a handful of recordings. It's about the context of what those recordings were made in. In this case, it was over the course of years, and there wasn't a good reason for a chunk of them. So the key reason why that distinction is so important to bear in mind is because in Canada, we are basically in a jurisdiction where you can record a conversation as long as you are a party to that conversation. It doesn't require both people involved to be agreeing to it. So the thing is that means that you can't hang your hat on saying, oh, well, this was illegal for the employee to do. Instead, it becomes a question of when the employee made those recordings, what was the reason for it? So if, for example, they are basically on their final straw and they record a disciplinary meeting, or they have to record the termination meeting, probably not cause. On the other hand, if they are kind of recording, for example, confidential discussions about your next product launch, then that is a lot more likely to be cause. So again, context matters. So the next case is the Kwong v. Lafarge Canada Inc. case. And that one was basically a good reminder of how, again, safety does matter, and sometimes it can be sufficient for cause, but context, consistent applying of policies, and also clear warnings is needed in order for that to stick. This case was basically one where the employee had a substance abuse issue, would have been a safety risk, and was essentially provided the opportunity, as consistent with Laforte's duty, to accommodate. Basically, essentially he was provided with an out. He was provided with the opportunity to go through the program and make sure that he wasn't going to be a safety risk before returning to work. And he refused to participate. So that was a pretty clear example of, number one, insubordination, but also number two, the company having pretty good basis to say, look, we have an obligation to all our other employees to make sure they're not in danger. Now, we're going to turn next to some examples of cases where we have not found cause. And the thing is, especially the Chereau and Cafe Laforêt case, that one is one that some of you may have even heard of, because it's one that definitely kind of surprised people. And I think that even some employment lawyers were certainly caught off guard by it, because the thing is that it was a case where there was evidence that the employee who was fired had touched the female subordinate on the butt on at least one occasion without her consent, and had also touched her on the shoulder and her back. So it wasn't a one-off, it wasn't an accidental bump, it was at least 3 separate incidents. But surprisingly, that was not cause. So the thing is, I like to think that with cases being so fact-specific, that that it would certainly be worth a discussion about whether you could terminate an employee for cause in those circumstances. And there's also probably cases where it will be cause. It's just that the problem is that in that case, I think that, frankly, the employer had also shot themselves in the foot a bit during the course of dealing with those issues, because they had basically tried to pressure him into signing a affidavit, which is a form of sworn evidence, essentially admitting to what he did, which would raise alarm bells, because then you're essentially saying, hey, RCMP, please arrest me and charge me with sexual assault. So especially given that that was the ultimatum for him keeping his job, you can see how the court was perhaps not very pleased with that step being taken by the employer. And that was reflected in the fact that they also awarded $25,000 in aggravated punitive damages to the employee because of that. So I think that there's basically 2 key lessons from this case, which is just, number one, again, it kind of illustrates how hard it is to prove cause and how careful we need to be with dealing with potential cause. And then secondly, it also shows how being overzealous and how you deal with the situation can backfire spectacularly, both in terms of increased liability, but frankly, also probably the outcome of the case. Because the reality is that, for better or for worse, judges are human. Just cause is remarkably fact-specific, and there's a lot of leeway in terms of how judges can interpret those facts. So the thing is, the company certainly did themselves no favors by having done that, because then it looks a lot less like a company that feels they have no choice but to get rid of someone to protect another employee, and instead looks like a company that was strong-arming someone who had harassed someone. I don't think there's a way to sugarcoat what he did, but the thing is, there's also, unfortunately, many ways to criticize what the employer did in response to it. So it's a good reminder that even if someone has done something really terrible like this, you still need to stay objective, and you still need to be careful in how you approach it. Now, sorry, I was told to keep my mic a little bit higher, so I'm actually going to I'm actually going to try to basically just hold it a little bit, if I can. Oh, okay, yeah, so it should be fine now. Yeah, so basically the next case was Timco and 4D Warner Enterprises. And basically that case is, yeah, basically this is the train derailment case that I was talking about. And it's a perfect case to illustrate the idea of how just because something is a admittedly quite major safety issue that did actually cause damage, that's not going to be the end of the story. The story isn't going to end until you look at the full context, which in this case was driven primarily by the fact that it wasn't clear that the person had been trained on what to do if he lost contact with the other employee. So basically there was essentially there was a loss of communication, which led to the derailment. And a cynical view of the case might say that the employee didn't actually lose contact and had essentially been sleeping on the job or something. But the problem is that the evidence was unclear on that point. And it was unclear that the employee had been taught what to do if he did lose contact. So basically that was a situation where had there been proper training and procedures in place, it probably would have been caused. But because there wasn't that bridge between policy and practice, it wasn't caused. So this case basically just is a really good reminder of how important it is to have clear policies and also to have through the disciplinary process. Now, the next one, so basically the next one we're going to briefly cover is just kind of what to do immediately, which is number one, you will make sure that you're gathering relevant evidence, especially if it's, so the thing is like with some things like performance issues, attendance issues, those kinds of things, that's probably not as important because you're going to have their HR file, hopefully. But where gathering evidence is contemporaneously is super important is if you have any sort of situation where there's going to be more than one version of what happened. So if, for example, there is a workplace, like let's say someone got into a fight, you're going to want to make sure that you gather the CCTV footage basically right away, because if you don't, it might get deleted depending on what your like surveillance policies are. And the other thing is that when you're dealing with potentially different versions of what went on, you may also need to consider whether you need to get a witness statement from the other affected employees. So those are basically two of the examples where it's extra important to gather evidence, but at the minimum, before letting someone go for cause, you'll want to have their full HR file. So if you go through the file and you say, oh, there are no written warnings that are saved to the file, you might want to at least pause and make sure that you're on good enough footing to do it. Now, the other thing to keep in mind is, of course, like that earlier case illustrated, you need to make sure that when you're investigating fairly and impartially, and basically you don't want to really go on a crusade against an employee. The other thing to keep in mind is, of course, just that seeking advice before terminating, especially if it's a relatively messy or unclear situation, is probably good practice because, frankly. And then as far as what not to do is, in most cases, and this will depend on the contracts that you have in place or the policies that you have in place, but you'll want to avoid suspending an employee without pay pending investigation in most cases. There are, of course, going to be exceptions, and we can always discuss individual situations as they come up. But as a general rule, when you suspend someone without pay, that could lead to just a constructive dismissal. And then the other thing is that when you're deciding on discipline, especially if you're considering termination, you'll want to consider, number one, getting advice, but also number two, weighing other options. You basically want to have at least gone through that exercise of thinking, is there another step we could take instead? For example, could we issue a written warning? Or could we put them on a PIP? Or could we give them a verbal warning if this is the first time this has ever happened? And the other thing too is also just that in most cases, you won't want to terminate someone for cause based on just one version of the facts. And because most of us represent both employers and employees at various times, we've seen kind of, and as employee counsel, I've certainly seen situations where someone has had a supervisor or a manager that just really had it out for them because they didn't like the fact that they were being demeaning to them. And then the employer kind of just took that one version of the facts and then terminated. And then in that kind of situation, you're dealing with not only a really weak case for cause, but you're also probably facing a prohibited action complaint or something like that. So basically the final thing is that there's this cautionary tale of home and Canada Limited, where basically it's a case that showed that there's going to be multiple consequences for if a company is saying that they have cause when there's no reasonable basis to have said that they do. So the thing is, for the most part, the court is going to be pretty nonplussed about if you say that you have cause and you simply and the court simply lands the other way. It's cases like this where you have increased costs or some additional bad faith damages, or often can be ones where you're, for example, saying that someone lied or cheated or stole, and they didn't actually ever do that they did. So essentially the idea is, again, this kind of dovetails with the earlier point about how you can't just go to the races with just being told something. You need to do your due diligence and make sure that if you're saying that someone has stolen from the company, that you have at least more than a guess that they did. Oh, sorry. Apparently that was not the last slide. This one is the last slide, though. So basically, the last thing is really just practices are, and again, workplace policies can do a lot of the heavy lifting, especially when we're talking about potential terminations resulting from safety, absenteeism, and the idea with workplace policies as well to keep in mind is also just that they do actually need to be specific to your workplace, because the thing is that, for example, like safety is going to be very different if you're a construction company versus if you are a retail store. And on the flip side, the retail store might be more concerned about having a social place as opposed to like just a safety policy. So just the more tailored they are, the easier it will be to enforce them if you need to. And also the harder it will be for a employee's lawyer to try to say that they weren't given clear enough instructions, or that they weren't told what would happen if they didn't comply with this, or that the policy was too confusing to comply with, which sometimes happens. The other thing to generally do in most cases is that you'll want to engage in progressive discipline, usually multiple warnings and eventually a final warning before you actually let someone go. Again, there are situations where sometimes you have no choice but to just act right away, but those are going to be rare. The other thing is, of course, that regardless of the form of discipline or the reason for discipline, you'll want to make sure that you are documenting discipline in your organization, especially if it's more than once with the same employee. Especially if this is the second time you've heard the person's name, you might want to start keeping a paper trail. And
Just with
that being said, should they have an advocate or should you have a second person, like when you do have verbal warnings? Is it necessary to, like, can they be one-on-one or should there be other people, like what's appropriate for verbal warnings? Advocate wise or the rule of two or whatever.
Right. So basically the question from the floor was whether there needs to be a second person involved if there is a verbal warning and like an advocate or something for the employee. And the thing is that generally speaking, the answer is no, there's not actually a requirement to do that. What you're going to want to do as the HR professional is you're going to want to be making sure that you are sending a follow-up email, or you are at the very minimum having notes on your end of what the discussion was. Essentially, you want to have something so that if they say that you, for example, were yelling at them and saying that they were, the worst person ever, that you can have something that will point otherwise. I would say that it's also a matter of proportionality. Basically, like the more serious the discussion is, or the higher stakes it is, the more likely that it is that it makes sense to consider having a second person on your ending. But yeah, basically for the most part, the idea is that if you're at the verbal warning stage, you're really truly giving the person a chance to correct their behavior, and theoretically you want to keep them, or at least you want to keep them enough. So basically the idea is that you don't have to have someone, they don't necessarily have a right to have someone with them. And a lot of times if an employee is the one saying that they want to bring a second person into the meeting, that's usually a sign to talk to us, because I would be concerned that they're going to be approaching the meeting with a game plan in mind already, as far as trying to set up, for example, constructive dismissal.
I have a couple of questions. Sorry. How does this apply, the seriousness of this apply, whether it's a unionized or a non-unionized environment? Like, can we skip the steps of progressive discipline based on the severity of the incident? Right.
So the first question was whether it differs in a union versus non-union environment. And the short unionized environment, you need to worry about the collective agreement and make sure that whatever disciplinary process is set out in the collective agreement is being followed. So a lot of times that's kind of where the process starts, is looking at what the collective agreement itself requires.
Let's say if there's no language. So let's say one of the four causes you said, like let's say assault, right? Let's say the collective agreement does not have language on assault technically, and that it's a serious incident, and the employer thinks it's very serious that they assaulted somebody, and we would like to terminate them with cause. Would it be applicable to override the collective agreement, or go to the last step of progressive discipline and terminate?
So the question was essentially whether there, for a unionized environment where there's a more serious type of incident like an assault, whether it can basically kind of skip to the last step of the disciplinary process. And I know that's not an ideal answer, but the honest answer is that it will depend. It's going to depend on the language in the agreement again, because the thing is, even if the agreement doesn't touch on that specific scenario, it's very likely going to have language in there that's that the disciplinary process will apply except for X, Y, Z, or it'll have some kind of language in there that essentially provides that you can essentially go to, for example, a final warning or termination, like if certain type of criteria are met. But other than that, it really would be a little bit more detailed and require a little bit more review. And I would recommend, honestly, discussing that kind of situation with either Chris or Mike.
Okay, so just to summarize, then they're more protected, I would say, than under a collective agreement versus a non.
Yeah, so the follow-up question was whether essentially a unionized employee might be more protected than a non-unionized, and I think that generally speaking, it's fair to say yes, for frankly a really practical reason, which is a unionized employee doesn't need to worry about paying a lawyer.
My next question is the Long versus Lafarge case where you quoted refusal to participate in a substance abuse program. So we have a scenario where we are working on something right now where the staff has some addiction issues and they have gone into a treatment program back and forth. But then the problem is even during their tenure or during their participation, they continue to depict behaviors that disrupts operations or other staff members, like inappropriate behavior through communication and stuff. And there's seen, and it's a safety issue technically. So, and this behavior continues, like we follow the progressive discipline channel, but there's no stopping it. Would there be an opportunity, even though it's the collective agreement, like this goes back to my first question, that we've done a series of investigations, we've done a series of progressive discipline on this person, but this behavior still continues. Would this give us to move a few more steps down the disciplinary?
So the question from the floor was basically whether when you're dealing with a situation where there's an employee dealing with substance abuse and has basically been difficult during like the substance management process, and has also been continuing to be difficult in communication with the employer and whatnot, whether essentially that could justify taking further disciplinary steps in the context of a unionized workplace. I'd say that regardless of whether it's a union or non-union, you still run into the same problem, which is that you have the question of whether you can terminate them, but then you also have, more importantly in that kind of situation, whether the organization has met the duty to accommodate the employee under the Human Rights Code. And the thing is, that is going to depend on the size of the organization, the extent to which the employee is being uncooperative. And essentially, it's generally speaking, the less time that has been given to the accommodation process, weaker it'll be. So generally speaking, like the earlier you are in the process, the more you need to continue kind of putting up with it and engaging with it. But it does get to the point where if someone is not complying with medical recommendations, that could like instead of outright refusing treatment, they may be for example just not actually participating in any meaningful way in the substance abuse program. That could be a situation where you've met your obligation as an organization. But I would say that whenever we're dealing with those kinds of scenarios, that's where we really justify our rates, because essentially the thing is whenever you're dealing with a more complicated termination, especially if there's a human rights component to it, it's partially a matter of flagging the issue. That's always step one. But then second of all, it's also about essentially providing you with what the rough level of risk is, because the risk is very rarely zero, and basically helping the organization make a informed business decision on whether their tolerance really has gone to the limit, whether this person is too problematic, and whether the potential risk of a human rights issue is either low enough or tolerable enough to proceed to termination.
Which was my next question, like what is the level of tolerance that the employer should have on this? Because let's say this goes on for a couple of years and every 3 months you need the staff member to keep reminding them of this again. What's the level of tolerance the employer should have? Like the employer is compassionate, giving multiple opportunities. Is there a timeline, or we can just take 2 years as a timeline and then proceed forward?
Yeah, so the question was whether there like a sort of guideline as far as how far a employer needs to tolerate that type of situation. And the thing is, again, it actually does depend, because it depends on partially the scale of the organization. The larger your company is, the more expectation there will be that you essentially absorb that issue and cope with it. Whereas the smaller and more disruptive, like basically the more damage that can be caused to the organization by having this situation linger, the less issues you'll run into from the accommodation perspective. The good thing is that our next panel is actually on human rights updates, so it's possible that they'll be able to cover some of this as well.
Thank you. Sorry.
Rowan and I are going to kind of build on some of what Jensen just said. We're going to look at some updates at the Human Rights Tribunal. Start off by looking at some procedural updates, so things that affect how a complaint is processed and adjudicated at the tribunal. And then we're going to take a look at some recent cases that will give some of us quite a bit of a shock. But to understand where we are now, I'm going to start by taking a look at how we got here. So a lot of the changes have come from the COVID-19 pandemic. And you'll see in some of the numbers on the next slide, there's a reason for that. So 2018 to 2019, just some quick stats, new complaints filed fiscal year, 1,736. By year end, they had processed 1,445 of those complaints accepted for filing. 291 were still in the screening process. At that time, the screening service standard, so for those who haven't dealt with a human rights complaint yet, when it's filed with the tribunal, after it's filed, the tribunal reviews it, makes sure that there's at least some basis for a complaint there. So, what the complainant is saying could potentially be discrimination under the Human Rights Code, and they could be entitled to damages. If it passes that very low bar, then it's moved on from the screening stage. So at that point, the screening service standard was to complete within 30 days of receiving the complaint. So within 30 days, it was either accepted or denied. And at that point, they were meeting that standard 45% of the time, so just under 50%. Now, that may seem like a shock already, but we will get even more shocking later on. So they issued a total of 426 preliminary decisions that fiscal year. And those are things like applications to dismiss the complaint, preliminary application, applications on timeliness, so was the complaint filed in time, and stuff like that. So the next fiscal year ends in March of each year. So for the 2019-2020 stats, this was just the beginning of when it was pronounced a pandemic. So these are kind of the first stats that we have to compare the status of the tribunal pre-pandemic and post-pandemic. So new complaints filed went down actually, 1,614. By year end, 1,226 of those were accepted for filing. The service standard, so remember they were meeting this 45% of the time the previous year. At that point, they were now only meeting it 16% of the time. So an almost 30% their ability to process complaints in a timely manner. At that point, they stated that hearings were being scheduled 1 year in advance. So once the complaint was ready to go ahead to a hearing, it was scheduled for 1 year later, approximately. So 2020 to 2021, the tribunal transitioned themselves to remote staff mediations and hearings. So before that, a lot of the staff was located in downtown Vancouver on Cambie Street. Mediations were also held in person or over the phone, and hearings were generally held in person. They also created the online complaint so before 2020, 2021, you had to file a complaint either by email, fax, or dropping it off at the tribunal. And by year end, they had 1,162 complaints just accepted for filing, and 1,163 still in the screening process. The average time to screen complaints for that fiscal year was 6 months versus the 30-day service standard. So 6 months just to decide whether it was going to pass on to the next stage. At that point, mediations were offered on an average of 4 months after the notification of a complaint proceeding. So once a complaint passed, then the employer or the respondent, if it's an employment matter, is given notification that this complaint is going to proceed. So at that stage, once notification was given, a mediation was generally scheduled 4 months after that notification. Their service standard was within 2 months, so about double the time. But with the screening delays, so the screening delays of about 6 months plus the extra 4 months, you're seeing a mediation actually not being scheduled until about a year after the complaint was filed. And hearings were now being pushed an additional year later than when a complaint was ready to be scheduled. So we're looking about 2 years to get to a hearing. For that year, the tribunal ended with an all-time high number of active cases, and that was 2,966 open cases at the tribunal. Moving on to 2024, 2025, the latest stats, we have 3,036 new complaints accepted or new complaints filed. So in previous years that we were looking at 1,400, 1,600, I think 1,700 we had. So more than double we're looking at. At the time of posting the report, they were only screening complaints filed in November and December of 2023. So about 2 years behind. And that's just to say yes or no if it's going to proceed. That's the employer hasn't even been notified yet if there's a complaint. They issued 740 preliminary decisions, not including those screening decisions, and they ended the year with 6,253 active complaints. So if you look at 2020 to 2021, we went from just under 3,000 to more than 6,000 now. So obviously the tribunal is in a bit of a pickle now. They certainly didn't have the resources pre-pandemic to take care of that many complaints. They're still trying to strengthen those resources, adding more mediators and more staff at the tribunal. But they've also implemented some new processes to try and affect this backlog. So one of the first things, effective March 31st, 2022, so this has been in effect for 3 years now, they implemented a separate process for mask-wearing complaints. So after the pandemic, we saw a real influx of mask-related complaints, vaccine-related complaints, and a lot of complaints just generally to do with COVID. So we've got a separate screening process for mask-wearing complaints. You can see the influx for mask or face covering complaints during the pandemic was roughly 88 pandemic-related complaints for just one fiscal year. So the year immediately following the pandemic. So the tribunal will now move to an immediate dismissal if a mask-wearing complaint does not include these two things. So number one, the protected characteristic. So it's not good enough to say, you know, I don't like to wear a mask. I can't wear a mask. They discriminated against me because I didn't wear a mask. You have to have a reason why you can't wear that mask. And if the protected characteristic is a disability, you have to identify that disability and give more detail about it. So they can't just say, I have a medical condition that prevents me from wearing a mask. Say what that medical condition is and why it prevents them from wearing a mask. So, you know, I have asthma and my doctor has recommended because I have breathing issues, I can't wear this mask. If they don't meet either of those, it will get immediately dismissed in most cases. The complaints must also not must not include a complaint based on orders of the provincial health officer or the provincial government, or a Canadian Charter Rights of Freedoms discrimination ground, because they don't deal with the Charter of Rights and Freedoms at the Human Rights Tribunal. Another thing that we had was applications to dismiss have changed quite a bit following the pandemic. So applications to dismiss were kind of one of the best tools in an employer's belt for defending a human rights complaint. You know, there always has been some bit of backlog at the tribunal for the processing, and application to dismiss was a large part of that. And so, you know, as an employer, you get served with this complaint, and one of the things you could almost immediately do was file an application to dismiss to try to get that complaint punted. And with that preliminary go to a decision from a tribunal member. And so the parties make submissions, it goes to a tribunal member, it sits in the queue until that person is ready to write a decision. And so this could have set, a complaint back months, if not, a year or years in some cases. And so because of that, I think the tribunal caught on a little bit that a lot of us were using this probably not as it was meant to. And so the tribunal first started by pausing the ability to bring applications dismissed. So in November of 2021, they said nobody can bring applications dismissed. It's paused. And they diverted their resources, their member resources, away from rating hearing decisions to focusing on working through the application to dismiss decisions. So they focused on one backlog at the, unfortunately, to cause another backlog. So then we had hearing decision backlog. After that, once they brought back application dismissed, they brought them back in a different format. So now we have the case path review process, which was started in the 2022-2023 fiscal year. And what that does, instead of being able to immediately bring an application dismissed, what happens is the complaint gets filed, gets served on the employer, parties have the opportunity to attend mediation. If they don't attend mediation or mediation is unsuccessful, then we move to document disclosure. Before mediation, the employer has to file their response as well. But after document disclosure, then the tribunal will review everything. A member will review it, and they will decide whether the employer will be invited to bring an application dismissed, so whether they're permitted to do that, or whether it goes straight to a hearing. So you could have a file where the tribunal says, I don't think that there's a reason for you to bring an application, so it's going to go straight to a hearing. Now, you can, that decision you could potentially judicially review, but now we have this process where you don't have the right to bring that application anymore. What I also mentioned is that responses are now required kind of at the outset from employers. So the previous process used to be the complaints filed, passes screening, and then we moved to mediation. And the employer wasn't required to file their response before that mediation. It was only after that mediation, if it's unsuccessful or if the party said no to mediation, that the response would have to be filed. Now, employers have to file their response within 8 weeks of being given that notice that the complaint is proceeding. Part of that, I think, is to make mediation a little bit more productive. Parties are going into this knowing both sides of the story, knowing each other's positions, and it also doesn't delay the process after that if the mediation is unsuccessful. All the cards are laid on the table. Everyone just has to do document disclosure. If the complainant indicates that they're interested in mediation at the time that they file the complaint, the tribunal also now preemptively sets a mediation date. So when they give the employer notice that the complaint is proceeding, in that complaint proceeding, they will say, we've scheduled a mediation for this date. This is all the information. If you can't attend, let us know. If you're interested, but on a different date. If you're not interested at all, let us know that as well, and then they'll just cancel it. But now they are preemptively setting that date to, again, kind of have a goalpost that we're working towards. The tribunals also introduced some new Indigenous initiatives. So in 2021, Indigenous identity was added as a ground of discrimination. They've also implemented a dedicated screening process for Indigenous complaints. That process I just kind of mentioned, where it's complaint screening, it passes, whatever. If the case manager looks at the complaint and says, hey, I think this needs more information, rather than going to the complainant, they go to a specific Indigenous tribunal member who reviews it and then determines what they need from the complainant, and then they work with the complainant to get that additional information. So there's a few extra steps for Indigenous complainants. They get a little bit more leeway now. Another part of that is there's Indigenous navigators. So case managers at the tribunal are essentially the point of contact for everyone on the complaint. They basically see the life of the start to finish between the parties and make sure that the complaint is going smoothly. An Indigenous navigator is basically a counterpart to that case manager. So they work with the case managers, but they work mainly with the complainant to help them with navigating and understanding the process. Case managers can't really do that. They can point you to resources, but they can't really help you with the process. Indigenous navigators can provide a little bit more of a helping hand. They've also implemented Indigenous practices for mediations or hearings. So parties can request this now. It can include, smudging ceremonies, prayers, having an elder present. It can also include Indigenous dispute resolution models. So not the colonial system that we're all trying to break down these days, but it's actually become a lot more culturally aware and culturally sensitive at the tribunal these days. And the last thing that's kind of affect things as of recent was the recent BCGEU and the PEA strike. So the government workers were on strike. That included the tribunal. And so the biggest hit was case managers. So case managers were entirely on strike. And, I just mentioned they are the life of a file. They are the that file going. And so without a case manager, there weren't people to regularly review the emails. There weren't people to conduct case management calls as they once knew, and just generally make sure that complaints were running smoothly. So it kind of brought the tribunal to a halt. They started by saying that emails weren't going to be responded to unless they were specifically marked urgent. The registrar was conducting case management calls. So usually that's something that's conducted by a case manager. And the result of this was the backlog continued to escalate. Nobody's monitoring emails. Complaints aren't moving because moving them along. So to attempt to address this, the tribunals decided that they are, and this is still ongoing, they're only going to look at emails between 8:30 a.m. and 4:30 p.m. Monday to Friday. If you send an email outside of this, you get a bounce back that says try again during operating hours. So no one can file anything outside of 8:30 a.m. to 4:30 p.m. Monday to Friday, which is a real hindrance to not only complainants, but employers. Like maybe you can't get to this until after your workday. Maybe you can't get to this until Friday or until Saturday or Sunday. And so it's hopefully interim, but that is the status of the tribunal right now, is you can only communicate with them and file things during those hours. Even scheduling matters too, like not just filing. If you're communicating with the tribunal to schedule a mediation or a call or something like that, that also has to be sent between those hours. They're also only reviewing urgent communications for the most part. So those communications have to be marked as urgent in the subject line. These communications involve communications about hearings, mediations within the next 4 weeks from October 30th. So we're almost beyond. Extension requests during that same period, application materials that require immediate processing, including fast track requests, and service of judicial review materials. So because that deadline is fast approaching, that 4 weeks from October 30th, I think we will probably either see an extension of this from the tribunal, or we will see a new practice direction that might alter this to some extent. I'm hoping they remove the days and the hours that they're going to be looking at communications, but we will see. So just some key takeaways with some of that. Cases are taking even longer to reach just the screening stage. So right now, as employment representatives, we're seeing 1 to 2 years after a complaint has been filed. I would say 1 is being generous, probably 2 to 3, for an employer to get notification. Because remember, first it has to pass that screening stage, and then the employer gets notified. So, this person may have been terminated 3 years ago, and you've purged their employee file and everyone's moved on, and now you're getting notification that they're suing you at the Human Rights Tribunal. So it's very scary stuff. It might be 3 to 5 years or more before a complaint reaches a hearing and a decision is rendered. Again, I think 3 is generous. And so the main takeaway from those two things is keep your employee records. even after an employee is left, the Employment Standards Act, they do have a requirement that payroll and employment records have to be kept for 4 years after they're created. So there are some policy considerations there. But I think just from a practical perspective, making sure that you're keeping employee records to some extent after an employee's moved on. The other consideration, with the applications dismissed, employers can't get out of these as quickly and easy anymore. Even if you're moving to, a mediation, that's still, so when it comes to a human rights complaint, be prepared for the long haul. If you can't or don't want to settle with the complainant, it could be 5 years before you get to that hearing. Something that Rowan will talk about when we look at the cases, a longer time getting to a hearing means that we're seeing a significant increase in some lost wages awards. So for those who don't know, at the tribunal, they can award lost wages from the date of dismissal, let's say, to the date of a hearing. So if you're taking 5 years to get to a hearing, you could owe someone 5 years of wage loss. There's some cases that Rowan will talk about, even short-term employees seeing significant awards like that. And the other thing that we're seeing, and this is something that we're going to kind of continue to watch, is employers have tried to raise in the tribunal process that this delay is causing prejudice to them. So, maybe they've purged their documents, witnesses have moved on, whether they've left the company as well, or I've even seen in some cases, witnesses passing away before a complaint is even processed. And so we've seen employers try to argue that. So far, it's unsuccessful. The tribunal has said, too bad, so sad. This is our process. This is all we can do, which again is very scary. There hopefully is some reprieve coming. There is a current challenge right now to the case path pilot direction that's working its way through the Supreme Court. It's in the very early stages, but we'll keep an eye on that and see how that affects things moving into 2026 and 2027. So I'm going to pass it over to you.
Do I need a little microphone?
Yes, you do.
Just, was there 2 questions
Oh,
for
yeah.
virtual, if I can still do one mic?
Yes.
This question, longer time getting to hearing equals much larger lost wages award. And then is it common to settle earlier successfully to reduce that potential 4 to 5 year wage loss?
So I think Chris and I actually reviewed these stats recently. The tribunal, this one just hold them, I guess. The tribunal actually has some really great stats when it comes to mediation. Their mediation process, one of the is it's free. It doesn't cost anyone. Anyone who's been through a private mediation in a civil claim can, be $5,000-$10,000. That's not the case here. It's completely free. They assign the mediators themselves. They're contracted through the tribunal. They're completely neutral third parties. So that's one of the benefits to mediation. And they have like a 70 to 80% success rate, I would say. In a lot of these cases, complainants just want to be heard, and mediation offers them kind of a preliminary opportunity to do that. But it also gives you the opportunity to try and solve this a little bit quicker and a little bit cheaper than if you're at a hearing 5 years later. Obviously, not everyone's going to be willing to settle. Not every complainant's going to want to settle, and maybe it doesn't make sense to settle based on where you guys are at a mediation or the complainant's expectations. But mediation can be a really, really helpful tool.
Great, thank you.
Okay, so for the next part of our Human Rights Updated, I'm just going to go through 3 recent BC Human Rights Tribunal cases, and just the opportunity to kind of
explain some important human rights legal principles that many of you may probably know, but it's nice to have a refresher, and then just some key takeaways for employers that these decisions have taught us. So the first one is Flynn and DF architecture. And this decision was about the employer's duty to accommodate disability in the workplace. So Mr. Flynn was hired as a project lead at an architecture firm, and he was immunocompromised. So this all happened during the COVID-19 pandemic, and the company had sort of a partial in-office work from home the amount of workers that were in the office at a time. And after he was hired, Mr. Flynn told the company he was immunocompromised and asked them if they could explore other options in terms of a work schedule. And the company responded and essentially requested, we do want you to come into the office. And then he resigned after they responded. And a very important point to make here is Mr. Flynn was still on probation, and he'd actually only been working there for literally less than a week. So very, very short-term employee. So he argued of his physical disability because they wouldn't accommodate his needs. And the employer argued that no, they actually had fulfilled their duty to accommodate him. Their request that he come into the office was reasonable requirement given his job. And they also argued that he was required to do a little more than just ask for the sort of general schedule accommodation. He needed to provide details about his medical situation, make some suggestions about what the employer could have done to support him. And so, of course, the key principle we can see and learn from this case is just how do you actually of discrimination generally. So it's not enough that you have a protected characteristic under the code and you experience an adverse impact in the workplace, like a termination or a discipline or something like that. They have to actually be connected. So your protected characteristic, such as a disability, has to be like a reason or a factor in the adverse impact that you experience. Another principle raised in this case is this idea of the bona fide occupational requirement. So this is essentially sort of a defense that the employer will raise, and they'll say, yes, okay, our action as an employer on this employee and their personal characteristic, in this case their disability, was maybe a factor. However, there's literally nothing we could have done as an employer. The things that we were needing them to do, it was a reasonable requirement in the circumstance, given what their job was. Our policies and requirements have been made in good faith. And if we were required to do anything more, it would really be putting us out as the employer and causing us undue hardship, sort of the legal term there. And all these kind of tests are laid out in your slides more clearly. I know we're coming up on our break, so I'm trying to just explain this in shorter, kind of plain language, but if you want more details, there are more on the slides. So a key factor of this idea of accommodation is that there's obligations and duties on both the employer and the employee. So, the employee has to actually tell their employer about the issues that they're facing and what their needs are. They have to, they need to provide info about what they need, and they also need to accept reasonable proposals that the employer will make. They can't just say, nope, this is the only accommodation that I'll accept. They need to kind of engage in a bit of a dialogue as well. And same with the employer, they need to take steps to investigate the issue, they need to ask questions, they need to assess the employee's needs, and then they actual substantive modifications to try to reach a solution that works for everybody. So with all those principles in mind, in this case, the tribunal did find that the company had discriminated against Mr. Flynn, and that the fact that he had to leave the job was an adverse impact related to his disability. And the tribunal also found that the company did not fulfill its duty to accommodate Mr. Flynn. So, they said you needed to do a little bit more. They felt that after he'd kind of raised this issue, said, can we talk about my schedule? do something about this. The tribunal felt that the employer needed to do more than just respond with their side saying, oh, like actually you do need to come in. And that Mr. Flynn had, brought it to their attention and they didn't do enough. And so the award in this case, and this is kind of a good example of what Courtney was talking about, we all remember this person was only employed for less than a week, but he did receive a wage loss award, and he claimed nearly 4 years of salary, because that's the amount of time it took for this complaint to go through the whole process. Now the tribunal cut this in with their final determination. This is still very substantial, because even cut in half, it was almost $200,000. And the tribunal, their reasons were basically, there was uncertainties in the workforce at that time. This put him in a tough position. He'd been on probation. He was expecting to have this job for a while. Those were sort of those reasons. And then he also received a $25,000 award for damages for injury to dignity, feelings, and self-respect. So these are additional damages on top of wage loss compensation that are meant to compensate the employees the actual harm that they face. So if it impacted their mental, if it impacted their life outside of work, impacted their ability to get another job, that's what those damages are for. So if you are, listening to this and thinking, seems like the tribunal may be left a few stones unturned, the employer agrees, and this case is actually going to be going through a judicial review because the employer did see a number of issues with the decision that was made. So some of those are, just their kind of application of the test for discrimination. They didn't really fully consider all the factors. Some key important things to mention are their issues with applying the meaning of the employer's duty to accommodate. So they said you should have investigated more once he raised it, but the tribunal didn't really consider that, was this employer already accommodating? They'd already put this policy in place to allow people to work at home, to work in the office, have extra safety measures in place. The tribunal didn't really consider whether these accommodations that existed were maybe already enough. The employer is also raising in this judicial review that the wage loss award was potentially kind of an arbitrary decision. The tribunal just sort of cut his claim in half without giving any real specific or reasons why they decided to cut it in half, just sort of vaguely cited the upheavals in the workforce and kind of his difficulties coming off of probation. And another one too, they didn't really consider the undue hardship that the employer faced. So those are just to name a couple. There's kind of a host of other potential procedural issues that the employer is raising. So we'll have to see what's decided once this happens. So this is one to watch going forward. But again, a key takeaway is just the significant wage loss awards that employers can face just because it's a really unfortunate side effect to be aware of when you're kind of making decisions about settling or your response or whatnot. So the next case I'm going to discuss is Knowles and On-Time Moving. And this one really covers the employer's duty to respond to complaints of sexual harassment in the workplace. So Ms. Knowles worked for a moving company, and she was bullied and sexually harassed by a coworker. And she did make several complaints to management, and there wasn't any change in his behavior. And so she eventually quit because she no longer felt safe coming to work. And she did make a WorkSafe BC complaint as well, which was substantiated. And the coworker, Joe, was removed from the workplace and disciplined. And another interesting thing that happened here was that she received, after she quit, she received texts from another coworker, sort of threatening the legal action she was taking, saying, don't do this against the company. It's not going to end well for you, that kind of thing. So her position was that the employer discriminated her on the basis of sex, and that the text from the coworker was retaliation, which I'll kind of explain what that is. And then the employer's position was that they were not responsible for the sexual harassment because they didn't really know about it, and by the time it came to their attention, they didn't have time to address it before she ultimately quit. And they also said, similarly, we didn't know this coworker that texted you. We're not responsible for their behavior. So obviously a key principle in this one is just the concept of sexual harassment in the human rights area. And so it can be something very blatant, like an actual assault, touching, and it can also be something a little more subtle, like just little comments, innuendos, those sort of more like micro harassment activities. And again, as Fiona mentioned, important to really drive home that employers are responsible for the discriminatory acts of their employees. And this is even if you're unaware that they're happening. Of course, it has to be in the course of the person's employment. So you're obviously not responsible for sexual harassment they do in their personal life. But if it's anything done like in the workplace or sort of in the course of their role as your employee, you are responsible for those actions. And employers also have a duty to take reasonable steps to address complaints of discrimination in the workplace. So once you hear something, once an issue, you do have an obligation to sort of take steps to investigate and do something about it. And there's factors the tribunal will use to assess whether the response is sufficient. You know, did you take it seriously, and were you responding sensitively? Were you actually able to prevent the discrimination? Those sorts of things they'll look at. And then another principle in this one is retaliation. So this is kind of the human rights version of the prohibited action we've been hearing about all day. Essentially that if someone brings up an human rights complaint or a concern, if the employer then, you know, disciplines them or terminates them or does something that affects them negatively right after, that in and of itself can be considered an act of discrimination because you're basically retaliating against them because they raised something. So in this case, again, the tribunal did find that Ms. Knowles was discriminated against and that the employer was responsible for Joe's conduct, the individual that sexually harassed her. So she had told her management about the issue, and they'd done some things like they had more closely, but even with that, the tribunal decided that, you know, they didn't have any policies in place for preventing sexual harassment. There was no formal channel set up for reporting, and they hadn't had any education in place for their management or staff about these sorts of things. So those were some of the reasons why the tribunal ultimately decided that the employer hadn't done enough. And as far as the retaliation goes, in this case, they found there wasn't retaliation because by the time, so when the text was sent, she'd only actually made a WorkSafe BC complaint. She hadn't even started her complaint. So the text couldn't have been retaliating against a human rights issue because it's not a human rights issue she raised. It was a WorkSafe issue that she raised. And again, the awards in this case was wage loss. So she sought, again, 5 years of wage loss from the date when this all happened until the decision came out. And that would have been $250,000 in wage loss. In this one, the tribunal deducted, so she'd been able to mitigate her damages. She was able to get another job before this decision came out. And she also received through WorkSafe BC. So all of that was of course deducted from her word, but still just noting that even if someone is able to mitigate their damages and does get another job, you still might be responsible for the difference. So just some key takeaways from this one, you know, take complaints of bullying and harassment seriously, try to act on them right away in a sensitive manner. Again, as Fiona was talking about earlier, it might be, you know, more work up front, but it's a really good idea to try to have reporting policies and procedures in place. And even more importantly, make sure employees are actually aware of those policies and procedures. And just doing that upfront work can reduce a lot
time, money, and stress for everyone in the future, and just make sure that you've done your due diligence and you can kind of point to your policy and say, you know, we've told people about this. This is out there. And then also be aware, and I think this came up earlier as well, WorkSafe BC conclusions can be considered by the tribunal in their decisions. So because the WorkSafe BC had already substantiated her complaint, this is something the tribunal looked at when they were determining the compensation. So just something to keep in mind, again, when there's sort of multiple forums happening at once, especially since human rights usually resolves much later than all the other ones. Okay, and the last, sorry, I'm speeding through this a little bit because I know our break is scheduled for 2. This is the last one I'm going to talk about. This is Christensen and Care Tenders Financial Services. So this decision is really about terminations that occur while an employee is on medical leave. And it also gives us a bit of guidance about those tough situations when there's multiple reasons going on for the termination, which happens a lot. Worked as a facility manager for a retirement community. And at the end of July 2019, her employer, Care Tenders, raised some concerns. The main one was about like a whole ton of overtime that she was accruing, and then they also just said sort of other issues generally, but they didn't really say what they were. And then a little bit later, July 31st, 2019, she went to see her doctor and was actually given a note that she was medically unfit for work and was suffering from severe depression. And so she went on leave from work. And while she was on medical leave, she reached out to benefits administrator just to ask about long-term disability benefits. And then her employer terminated her 1 week later while she was still on her leave. So
don't do that. Spoiler, don't do that.
Yeah, not a great idea, which you'll soon see why. So her position was that the fact that she was on medical leave and the fact that she was making these inquiries about her benefits were a factor in the employer's decision to terminate her, and therefore it was discrimination. She also argued that this discrimination caused her an ongoing inability to work for 4.5 years. The impacts of the discriminatory conduct of the termination, she wasn't able to get another job for 4.5 years. That's what she was arguing. The employer argued that no, this termination was nothing to do with her medical leave, nothing to do with her asking about benefits. It was due to her poor performance and this excessive overtime that she was racking up. And the employer said, we weren't aware at all of any of these medical issues that were going on. And that they also argued that the tribunal shouldn't find that they should basically determine she doesn't have a disability at all because she didn't provide enough evidence. There wasn't a doctor that came and talked about it. She didn't disclose medical records. And so because of that, the employer argued that she actually didn't even establish that first step of the discrimination test that she had a protected characteristic. So a key principle from this one, workplace stress and anxiety may not always amount to mental disability under the code. So as I'm sure we all know, there's certain levels of stress and anxiety that come along with being an adult working in this world. And they're not always going to amount to a protected characteristic under the code. It's going to have to be more than that. Key principle is this idea of inferences of discrimination. So it's rare to have a case where there's sort of very cut and dry evidence where the employer says, yes, this disability is why I terminated you. Like that's usually not going to happen. And so the tribunal basically says if there's enough evidence, if there's enough clues kind of pointing us in the direction, and it would be reasonable for us to assume, and it's more probable than not that this act was because of their protected characteristic, that's enough to decide that discrimination existed. So this is especially important in these cases that are about timing. So when someone leave and then you terminate them while they're on a medical leave, this comes up a lot because their tribunal's really looking at the timing of it all and like, can we assume that that's why? Just as something to really be careful of. So in this decision, they found that Ms. Christensen did have a mental disability at the time of her termination. It did go beyond the stress and anxiety of work. She was suffering from severe depression. She didn't need any more medical evidence than she provided to show this. She had a doctor's note, she had oral evidence explaining what she was experiencing. And mentioned that the employer, if they wanted these medical records, they could have asked her to disclose them throughout the procedure, and that's not something that they did, which I'll touch on that point after this. And also they decided that, even though there were these legitimate concerns about her work performance and the overtime and all of that, the timing of the termination did give rise to a reasonable inference that her mental disability was at least a factor in her termination. So they found, the employer, they had some knowledge of her mental health condition at the time. And so even if it was a reason in her termination, it was a factor in the termination, and that was enough. And they did note that if there was evidence that the employer had decided to terminate her before she went on leave, like if they had an email or correspondence or something that says, we're going to terminate this person, and then they found out about the medical condition, the decision might have been different. But that's not what the evidence was in this case. And so with regard to her claim that the discriminatory act caused her an inability to work for the next 4.5 years, the tribunal did disagree with. They only ended up awarding her 8 weeks. I mean, I shouldn't say only, still $8,000 of wage loss, but that was certainly less than the 4.5 she was claiming. And they determined that, of course, this discriminatory conduct, the termination, did exacerbate her mental health struggles and did maybe prevent her from securing employment for a little while, but they were not prepared to accept that went on for 4.5 years, and she didn't have the evidence to show that. And she was also awarded $15,000 for injury to dignity, feelings, and self-respect. And quick interesting point about this one, the employer actually applied for costs against Ms. Christensen, stating that she'd engaged in improper conduct throughout the proceedings. There was kind of a host of issues that they took. They said there was various procedural issues about her disclosure, her allegations were based on speculation, they were disingenuous, things like that. A key one is number 3, which I mentioned earlier, so failing to disclose her medical records in advance of the hearing. So this is just something to think about because, while a party to an action has some obligation to disclose relevant, it's kind of up to them. Like if she doesn't disclose it, she loses the ability to rely on those documents. But it's only really harming her. And the tribunal did say, you, the employer, if you wanted to see these, it's something you could have requested to see. So again, just, thinking about what documents should we be actually requesting and demanding to see before it gets to the actual hearing. So again, the kind of key takeaways here is that the timing of termination can be really important because it can create inferences of discrimination, even if you have some extremely legitimate performance issues and all of the host of other issues going on. If your timing's wrong, it can really cause you some issues at the tribunal. So just really be careful about that. And again, that the protected characteristic only needs to be a factor in the decision to terminate. It doesn't need to be the first reason, the second reason, the third reason. There could be lots of other reasons, but if it's one of the factors, then they may draw an inference of discrimination. So yeah, that's kind of the review. There's lots of other cases out there. They're all posted publicly for the most part. So you can definitely take a look, and there some like we do, I'm not sure, but yeah, that's kind of it. So I don't know if anyone has any questions. Okay.
How long would you say the employer should have waited? Let's say she goes on her leave and then she comes back. Is there a time period they should have waited before they enacted the termination?
That's a good question. I mean, so once someone comes back to work. That usually means, they are medically fit to work again. So their medical issue or their disability is no longer preventing them from being in the workplace. So your decision to terminate them wouldn't be so closely tied to their medical issue. So I would say once they're back and their doctor has cleared them to be fit for work, and then you're raising these things, that I think you'll find a little less issues with the timing at that point.
I had another question about timing. Let's just say this employee went off and took her disability and she didn't come back a year, like she's still gone after a year. So can you terminate for after a certain amount of time? How long are you obligated to keep that position open?
So I'm litigating a case exactly like that, to give you an idea. Not even a year. He was gone for 4 years. So it's just whether them being off is a factor. Now, the considerations in scenarios like that, where they've been off for a significant amount of time, that's where you start getting into the territory of, is it frustration? Because then you may have a reason where technically his disability is why you're terminating him, but the frustration of contract has arisen, and so it's given you a justification for that discrimination, let's say. And so those scenarios are a little bit more complex. For those type of things, anytime you're dealing with wanting to terminate someone on medical leave, call a lawyer, please. You can, costly it can be. Even with the WCB and the mitigation offset in that on-time one, she got 5 years of wage loss. And so, especially right now, legal advice is very important at the outset. I don't think that there's a magic rule for these types of things. I think I was just going to add on what you said, Rowan. Even when they get back, if it's too close to when they get back, there's still potentially a human rights complaint there. And so there's really no magic rule of thumb. The best thing to do is to just talk to a lawyer and figure out the best way out of that. Maybe you can package it's not as reasonable for them to sue, and get them to sign a release and things like that. Yeah.
I don't know if this is appropriate to ask them, but like if the employee can't get approval to return, is there still an obligation to give them time indefinite?
Like let's say they're like permanently disabled, let's say never return. Instead of, and that's where the frustration more so comes in, because it's different from someone being off and their doctor saying, we're going to reassess. They might be able to return in the future. We're going to keep reassessing every 3 to 6 months or whatever it may be. There's a doctor saying this person's never going to work again, whether it's with you or anyone else, they're never going to return. That's more where you get into the frustration of contract scenario. It's whether they are unable to perform the core duties of their job at the employer. So, yeah.
If an employee has filed a case with WCB as well as with the Human Rights Tribunal, they can have another case on the common law, can they?
They could. Now, the issue that they run into, and we see it all the time. I've seen ESP complaint, human rights, civil claim, WCB, like I've seen them all concurrently. And the reason that people do that, number one, leverage. And number two, is sorry, I'm supposed to repeat the question. So the question was, can someone bring a complaint in WCB and human rights and still have a civil claim essentially? And yes, they can. So we see it all the time because A, leverage, B, you see the delays at the Human Rights Tribunal. Court system is also a little bit delayed, but not that delayed. And so usually going to get to a hearing faster in the court system, but you bring all those complaints for leverage from a plaintiff's perspective. So they can bring all of those, but the issues that they run into is overlapping remedies. So you can't have, common law notice, lost wages at the Human Rights Tribunal and lost wages at WCB, let's say, over the same period. So if they go to, trial on their civil claim and their HRT complaint is still ongoing, and they get an award at that trial of 4 months, the tribunal is going to factor that 4 months that they already got into an award at the tribunal. So yes, they can bring them all, potentially run into overlapping remedies, but that could potentially help you as well as an employer. You could potentially try to say this needs to be deferred because they're already claiming this remedy in another avenue. So if they have a civil claim where they're claiming aggravated or punitive damages, maybe you say that's similar to injury to dignity damages. There are cases that say it's not, but sometimes they will. Sometimes the tribunal will defer the human rights complaint until the civil action is done. Perfect. So Jensen and I are on the same page.
I have a question in regards to the medical documents. So the employer should have asked for some medical documents, but normally the employer is not really allowed to get detailed documents. So what kind of documents would the employer be allowed to get?
Yeah, so any of the documents that are sort of allowed, I'll repeat the question. The question was, what sort of medical documents would the employer be allowed to obtain during the human rights process? So once you're in like a human, there are certain levels of document disclosure that you're allowed to request that wouldn't necessarily be allowed. You couldn't request just in the normal course of employment from somebody, but because they've made a complaint against you and you're now in this sort of like adversarial litigation process, you can request them. It could be a host of different medical documents. The level that you have to disclose in litigation is much higher than the level you disclose just in the normal course of life and in employment. And again, in that case, the employer was sort of saying like, well, you didn't bring enough to the table to show that you had this disability. And then the tribunal is saying, well, you as the employer could have asked for it. It's just kind of important to think about those procedural steps to take before getting to the hearing. Even in the architecture one, the first one, there was this doctor's note that was brought up at the hearing itself. So it wasn't even disclosed before the hearing happened. And the tribunal actually made decisions about accommodation, about the claimant, Mr. Flynn's disability based on that doctor's note. And the employer hadn't had the opportunity to like cross-examine the doctor, to really analyze the document. And that's one of the issues that's being raised on the judicial review as well. I think just a good idea to request them before the hearing.
Could she have requested them, could the employer have requested them when she gave the notice? She said, I'm going off, and she has a doctor's note, and then they terminated her 1 week later. So when in that time period could they have requested that medical evidence?
Yeah, there's more limited things you can ask for if someone's just going on a medical leave. If once they allege a complaint, there's a higher burden of like proof that they have to give you, basically saying you did something wrong. But if someone's just going on a medical leave in the normal course of employment, you can't really ask for a ton of details about it.
So I just want to briefly jump in on that since it's something that I deal with semi-frequently, even just from the LTD side of things. And basically the idea is that the key restriction is you can't ask for a diagnosis because the idea is basically no one but the doctor is qualified to assess that. What you can ask for is you could, if needed, basically if the doctor's notes are super vague and you're trying to accommodate the person you have no idea, you're able to ask them for details regarding what their limitations are and what duties they're capable of fulfilling. So sometimes that's like in the form of a pretty detailed letter from us that's tailored to the specific role and stuff. But yeah, basically that's usually the way around that.
And if they let her go on LTD, they would have gotten a lot more documents. So.
One last question. When we're talking about sexual harassment and the employer's responsibility there, how responsible is the employer when it's a contractor or a client that's doing sexual harassing?
Yeah, yeah, there is actually a case about that. Yeah.
Yeah, multiple employer workplaces fall under the BC Human Rights Code. There's a case from, I want to say 2017 or 2017, I
Yeah.
think. There's a case that's exactly on that point, that multiple employer workplaces, all of this applies. So if it is a worker or employee from a different workplace, it can all fall under the BC Human Rights Tribunal, which is why, again, going back to policy stuff, having a good information like piece based on your workplace and circumstances about who it all applies to makes it known to everybody what's going to go on.
If the person sexually harassing is a person from another company and you have no authority over them.
Yeah, so this is where it gets a bit complicated, and to be honest, if I was on for that individual being sexually harassed, I'd be going after both employers. And you, as the employer of the employee being harassed, perhaps I'd be looping in that other employer and saying, no, they're vicariously liable for their employee's bad conduct. Our employee is just the victim of that bad conduct. So we're not creating the bad workplace over to you. So it becomes a bit complicated.
So it's your obligation to protect your employee though. So if you're aware they're going to a client and a client treats them as top dogs, then what's your level of obligation to withdraw them from that client and sub someone else?
That actually falls under, that'll start falling under section 312 that Chris talked about on Work Safe BC. It's kind of overlapping again with human rights issues depending on exactly what the unsafe issue is. And yeah, you do actually have a responsibility under section 21 of the Workers' Compensation Act to keep your employees safe. And then under section 13 to keep employees free of the Human Rights Code. So as soon as a complaint gets made, like if they make a complaint to you, so-and-so at the client department or the client office is constantly asking you on a date to use a sexual harassment example, you're saying, no, and you're probably reporting it to that person's boss.
Yeah, so like, I guess the final thing to add on to those questions, which are essentially like what happens if it's a third party that is harassing an employee. And basically the thing is I'd say the first step is that if at all possible, you want to be removing the employee from that situation. Like, so for example, if you can, put them to a slightly different part of the office, or you can have someone else present. Like essentially the idea is that if you can do things to minimize the risk, then you're expected to do that. And that's also probably going to be very helpful as far as defending any sort of complaints arising from that.
It takes approximately 4 months for Canada Immigration to issue or to process an LMIA. Now, when you're the employer and you need that person to come in to work on your products or your services the next day, there are some exemptions to the LMIA. And as I said, I'll go into further detail on the November 26th presentation. So please let Darcy know about that. While IRCC can also issue work permits, we should also note that ESDC, IRCC, and another favorite acronym of mine, CBSA, standing for Canada Border Services Agency, they actually work together to do these audits. Recently, as a couple of weeks ago, CBSA actually has started working with the Royal Canadian Mounted Police to start enforcement measures. So when they find people who are actually violating any of these audits or any immigration matter, they will have them picked up and in order to have them removed. So that's just something to be aware of. So why do we have these rules and regulations? We actually need to look at the Immigration and Refugee Protection Regulations, which is specifically Section 209. And it's in order to protect the health and safety of temporary foreign workers. Unfortunately, there has been a spate of individuals who have been abused when they've come to Canada. They're coming to work, and employers have sometimes abused them mentally, physically, or even tried to deduct their wages as a sort of repayment for all the costs the employer had to have in order to bring them to Canada. So what the rationale of all of these audits is to make sure that the temporary foreign worker has the same rights as a Canadian in respect to federal, provincial, territorial employment standards and collective agreements. How are people or how are companies being selected? Does anyone have any sort of, has anyone, out of those, sorry, that have been audited, do you know why you were selected for an audit? It can be for any reason. So it can be a random reason. So ESDC can go to Canada Business and just randomly select a name from the Canada Business Registry. It can be because of a history of non-compliance. Where would they get a notification of the fact that there is non-compliance? Anyone want to hazard a guess as to where they might get, where any of these bodies, anyone want to hazard a guess? No? Okay, it could be from anything from potentially a poison pen letter. And to make things easier for the temporary foreign workers, what they're now doing is they've created what they call an online reporting tool. So temporary foreign workers, if they're too shy to come up and say, I believe my employer is abusing me, they can go online and they can say, employer X has been doing this and this and this. ESDC and IRCC will take this seriously, and they will look into doing an audit on the company to make sure that the individual's rights are protected. One other reason why there might be an audit is from the Emergencies Act or the Quarantine Act. And everyone's thinking, well, that was some time ago. But COVID wasn't that long ago. So, you know, anything could happen. And look how quickly COVID started and what the implications and ramifications were. So anyone that had a temporary foreign worker coming into Canada during the COVID period, I would say anywhere from beginning of 2020 to probably end of 2024, be on notice. They are aware of you as a company and they can audit you because of the notification on this basis. So what type of audits are there? There are two. One is a paper audit and one is an on-site audit. By far the easiest is the paper audit. This is where ESDC or IRCC will write to you and they'll say, we would like some information on person X, so one of your temporary foreign workers. Or if you brought in several temporary foreign workers, they might say that particular group that entered between this date and that date. Usually you're given about 7 to 30 calendar days, depending on how many people they're interested in looking at. You do need to respond to this. It's not something that you read it and put it to one side. You need to respond to it within that date. We are able to help. We do this all the time. The more scarier one is the on-site audits. And this is where RCMP, CBSA will actually come to the premises and say, everyone, pens down, we're going to start talking to you. We're going to talk to HR, we're going to talk to individuals, whether they be Canadian or temporary foreign workers. We're going to talk to everyone. Now, why is that a problem for you? It is because that means it's downtime. That means your products, your services are not going out for however long the authorities are on your site for. They don't actually need a warrant to come onto the site if it's a commercial property. And usually they're very nice. They sort of come to you and say, could you just give us all these documents? If you can't give them these documents, that's when they stop everybody in your employment and they say, I need to talk to you, person X, can I confirm? What's your SIN number? What is your status in Canada? They're entitled to ask that. Employers are not. That's the interesting thing. What are these inspectors looking for? Well, they're looking to make sure that you as the employer have been compliant. You're not only compliant with the employment standards, but you're compliant with the LMIA that was issued. Has the business changed? Has the job position changed? Has the wages changed? Is there any abuse of the human rights? And we heard from the previous panel about all the various human rights that are available. Is how accurate is the LMIA? And I don't know if this applies to anyone here, but if you have any seasonal workers, you are mandated to provide them adequate housing. So that's something to be aware of. Okay, so what would happen if you failed an audit? Well, they are nice, as I said. They will give you an opportunity to explain. So if you fail the audit, they will write to you again and they'll say, we noticed this failure. And they will list the failures and they will ask you to explain each and every one. So once the response has gone back in and you're still found non-compliant, you can be issued with a warning, which is usually a written warning and more or less a slap on the wrist and to learn from the mistake. It could be a fine, and we're talking substantial fine, hundreds of thousands of dollars. There could be a ban on future LMIA issuance, and there could be a revocation of the current LMIA. So imagine your workforce, if 10% of them are on LMIAs and ESDC revoke that LMIA, Canada Immigration can revoke the work permit, you've lost 10% of your workforce. That's why these consequences are serious. The last one is publication on the government's website. And I've actually included the link on here, and you can click on the link, and it's not the best marketing scheme. It's otherwise known as the name and shame. So Canada Immigration will name the companies that have fallen foul of the compliance. They will list how much you were fined. They will list any sanctions taken against you and how long, for example, if you have been banned from any LMIAs, how long you have been banned for. That is not a good marketing strategy for clients, for employees, for anyone. So how can we sort of protect the company? I prepared a sort of flow chart here, and I believe that all of you have a copy of this. So one of the first things I recommend is you run your HR systems, whatever systems you have, if it be Employment Hero, HUMI, whatever system you have, pull up the insurance numbers that begin with 9. That denotes that they are a temporary foreign worker. If they are a temporary foreign worker, you then have the right to ask them for a copy of their current work permit, a copy of their passport, only the biodata page, you don't need every other page. And the reason why you need the biodata page is because you need to make sure that that's the same person. I could say that I'm Rowan and I can work in Canada. Well, until you see a biodata page of me or my passport, you won't know if I'm Rowan or anyone else. The other things you need to prepare, having done so many audits myself for clients, is copies of supporting documents. So sometimes clients will come to you and say, well, yes, my work permit is expiring in a couple of days, but I filed an extension and that allows me to stay working until a decision's made on my application. So that means you need a copy of their permit that's about to expire, a copy of their passport, and a copy of the letter that confirms that an application for an extension has been made. The other thing that they ask for in the audits is copies of payslips, T4s. If you've let that person go, a record of employment copy. They will also ask for timesheets and expense claims if, for example, it's a contractor or someone who is working per timesheet. Once you have these folders put together, whether you keep them virtual or you keep them as paper files in the office, you also need to do what we call bring forwards in the legal industry. And this is to set your calendar at the following intervals. 6 months. So imagine you have an employee called John. So John is his work permit is due to expire on the 1st of September. You need to set a bring forward or reminder the 1st of March. The reason being is if you want to extend John for whatever reason, that's when you contact us. We will find a strategy to extend John, but we need 6 month lead time because it could be we have to do another LMIA, which, as I said before, in itself takes 4 months to process, let alone us prepare it and submit it. Then you do a 3 month follow-up. So if at 6 months, John says, you know what, I'm not sure I'm going to stay in Canada, I might want to go back home, or, you know, I'll think about it and I'll get back to you. Life happens, and all of a sudden you're at 3 months. You follow up again with John and you say, hey, do you still want to stay? We need to start working out a strategy for you. That's when literally the cutoff is for us to be able to do anything for you to keep John in Canada. At 1 month, the reason why we recommend that you have a bring forward at that point is because that's when you need to start preparing, oh my gosh, John's not going to stay. I need to find a replacement for John. I need to start winding him down so that I can get someone else to replace him, or we can terminate that position. We have to start getting ready to prepare his record of employment. And then obviously on the final day of the work permit expiry, that's John's last day. He cannot be paid any further than that. Obviously, if he's got vacation paid accrued, that's fine. But he cannot be paid any further than the last day of his work permit issuance. You also have to keep a record of all of these files for at least 6 years. IRCC, ESDC, CBSA, they can come and ask for an audit for up to 6 years afterwards. So John might have come and gone a long time ago. You might have forgotten all about John. But here we are with this audit and you have to deal with it. So at least 6 years, I recommend 7, but just 6 mandatory. Then we also talk about voluntary disclosure. So that sounds a bit ominous, doesn't it? Voluntary disclosure is once you have done all of these tips and you look through your files and you say, oh my goodness, we found a failure here. We've got an issue with Mary here. You can voluntarily disclose that there's been an issue, a sort of error. And why that is important is because if there is an audit, an ESDC look back to see whether or not you voluntarily disclosed it, it will go in your favor. So they won't fine you as much if you came to them and went, oh, we made a mistake. But before you voluntarily disclose, come to me, talk to me, I will tell you what you need to do and whether or not you need to disclose it. There's a criteria for it. So please do not go ahead and say, oh, look, we've got 101 employees we made a mistake with. Talk to me. I'm able to tell you whether or not you need to voluntarily disclose. And that leads me into my penultimate screen, which is what can we do for you? We can assist you on all audit processes. We can liaise with the government on your behalf. We'll help you prepare for any audit. We'll put the package together. We will submit it to the government on your behalf. And we can also do anything you need us to do to keep your workforce in Canada. We'll do extensions. We will look at options. Obviously, it's got to be suitable for the employer and also the employee. But we're definitely here to help. So please just reach out to us and let us know how we can help. So I think with that, I can open it up to questions, or shall I pass on to Darren? Questions? Someone at the back.
I
I think it was a couple of days ago, there was an announcement about a new pathway being possible for temporary foreign workers to PR.
Yes.
Do you have any insights or guesses about that you can share with us?
Not at this moment, just mainly because everything changes so quickly with immigration. And they're talking about all these different pathways, but they're also talking about shutting down some programs. But I'm happy to go away and research it, and then I can give you specific details. If I can get your contact details, and then I'll give you some specific details about that program.
Thank you.
No problem.
I have a question.
Sorry, yes, I think we need the microphone. Oh, sorry.
What if an employee has a work permit, let's say it expires end of December, but the employee has applied for a PR status? Now, does the person maintain what is called?
Maintain status, yes.
Maintain status.
Okay, so just because someone has applied for permanent residency doesn't mean that they have maintained status. They still have to keep their temporary status alive. So when you apply for permanent residency, depending on where you are in that process, there is an option to apply for what they call a bridging open work permit. But there are specific eligibility criteria. So if you think about it as a parallel, which is that if we use example, John has temporary resident status. He's applied for permanent residency, but until he gets permanent residency, he has to keep his temporary resident status alive. He has to keep it maintained. Just because he's in the express entry pool doesn't mean that he is an employed status. The bridging open work permit has specific criteria, and you need the bridging open work permit to be able to maintain your status.
So if this person doesn't get the PR by end of December and the work permit expires in December, I can't let this person continue to work.
Well, you would need to see that they have extended their temporary resident permit, or sorry, their temporary status in Canada. So, for example, if they have extended their work permit, I don't know what type of work permit they have, but if they haven't applied to extend their temporary work permit, then the fact that they're waiting for permanent residency doesn't save them, doesn't keep them in Canada. Not that by itself.
This is a postgraduate.
So the other thing you need to know, and this is sort of going a little off topic, and I know that Darren and Sandy really want to talk about their topic, but but the one thing you need to know about postgraduate work permit is it's a maximum of 3 years, and it's a once in a lifetime work permit. Once someone has hit the 3-year maximum, they cannot extend it anymore. And there has been some rumors and some people saying, oh yeah, you can extend your postgraduate work permit. That's not the case. It's a 3-year maximum. No problem. There's a gentleman here in front.
Sorry if this is not related. But,
No.
As an employer, when we post jobs and there's some questions that we ask under screening, the general question that's generally asked is, are you legally eligible to work in Canada? Yes or no. But is there any restriction on an employer to put saying, can you explain your status in Canada? Like, are you a citizen or permanent resident or temporary foreign worker or student or other? Is an employer able to do that on their screening or application? Or is there any, or legally are we not allowed to do that?
This is where immigration and employment overlap. So this is where I'm going to lean on my learned colleagues here. But essentially, in Canada, for immigration purposes, I know people, a lot of clients have asked me that, employers have asked me that, can I ask what's their status? I'll defer to, let's do the employment side first.
Sandy's graciously left this to me. So I think for something like this, you have to tread carefully.
Sorry, I wasn't going to punch you.
That's okay. So I think you've got to tread carefully with this. There are protected grounds you want to be aware of when you're asking questions like this. I think if you get an answer that you aren't expecting on the sheet, you can do follow-up questions. Just be careful, because if you do deny someone a job based on certain requirements or protected characteristic, you can walk yourself right into a human rights complaint. If you're being required to undergo certain things like an LMIA or whatever else to bring this person on, there may be other reasons why you maybe aren't able to do that. And so I think you want to keep the questions very general, and then you can do follow-up questions in the interview. It's probably the safest way to do it.
Is there a resource that IRCC or anything that says these are the only questions you could ask?
So this is where I think employment and immigration sort of counteract with each other, because for immigration purposes, as an immigration lawyer, I'm going to say to you, the employer, do you need an LMIA? Are you sure this person's not a Canadian? And then my employer colleague would say, oh, you can't ask those questions. So this is where it's a little bit of a head-to-head. I mean, I've worked with Chris before, and we've sort of put in employment contracts. There is wordings that you can put in. So instead of it just being, oh, this is a permanent offer or whatever, it has a little caveat, which is subject to you having the authority to work in Canada. So would it be possible for someone to answer the question, if the employer says, do you have the authority to work in Canada? Would that be considered discriminatory in the employment world?
I don't think asking if they have the authority or the eligibility to work in Canada, because it's something you legally need to know. You can't illegally hire someone. That's not going to be protected. But I think when you start to get into their status, where they're from, things like that, that's where you start to tread in dangerous territory. So there is contracts where they do have requirements that you must be legally eligible to work in Canada. I think you can ask that. And that may give you part of your answer, and then you may have to drill down a little later as to the context and the degree to which they're legally eligible to work in Canada.
Thanks. Appreciate it.
Perfect.
So just kind of tagging on to that, if a candidate says that, yes, I'm eligible to work in Canada, but then they don't disclose that they have a closed work permit and not an open work permit, and they're trying to apply for other companies outside of a closed work permit situation, and you don't find out until after they're hired because you don't want to intrude and ask for more.
But I think that's sort of where we're going with the contract, saying subject to your ability to work in Canada, because one of the first things you're going to ask for as soon as they sign the contract is, can we have your SIN number? Can we have your bank details to be able to do payroll?
So once you find out that they're not actually eligible to work for you versus a specific company that it's a closed situation, you can say like, sorry, you have the contract situation.
Sorry, say that again.
So like once you find out that they are not eligible to work for your company because it's a closed work permit, even if you've already signed that contract with them, you can say like, I'm sorry, like you don't meet your contract.
At that point, in my view, from an immigration standpoint, if John has a work permit for company A and then comes to work with you, and you only find out because he submits his SIN number and it says 9, as soon as you see the SIN number beginning with 9, that triggers you to say, John, can I have a copy of your passport and your work permit? And if it's for company A, not your company, he's not eligible to work. So that's where that clause comes in, subject to your eligibility to work for us, right?
Perfect. We actually have that situation, so good to know you did it right.
Perfect. Okay, any other questions?
So let's say an employee's work permit expired and they granted an extension, how often should I follow up?
Okay, that's a really good question. I'm glad you asked that, because currently a work permit in Canada, an extension, is currently taking 226 days. That's phenomenal. That's even records for as long as I've been doing immigration, which is more than 11 years. So when I see those extension letters, you'll see the date that the extension was submitted on. And then underneath there, you'll see this letter is valid until X date. I usually follow up 3 months after the submission of the extension. And then after that, I follow up 1 month. After that, I'll follow up every month after that until they get a response. So if, for example, John applied on the 15th of January, I would then follow up with him on the 15th of April. And if he still hasn't received a response, 15th of May, 15th of June, 15th of July, and so forth, until he gets a response.
Okay, so let's say it's been 6 months, we're being audited. And what if the employee was just billing?
Yeah, so then if you're audited, at that point, you can say to the employee, I would like to see a screenshot of the application, because invariably they would have submitted the application themselves and it's on their portal. And on the portal, it will always say, we're still processing your application, or it would say, a decision's been made, it's been approved or refused. So you can, I don't know if that infringes employment law, but you can ask for a copy of that screenshot from their portal as proof that it's still in process. So if you're audited, you can go to John and say, look, we need this document, so please give us a screenshot of your portal to prove it's still viable.
And with AI, you can fake that. But then it's not going to be on the employer.
Well, you've done your best efforts. The whole point is that you've done your best efforts. You, as the employer, are not hiding anything. You are doing what you can. One of the things that you can't control if someone is photoshopping things or what have you. But if it is audited, you say, this is what the the individual sent to me, and you make sure it's by email so you have a record of it. And then if they come back and say, well, actually, John was refused 4 months ago, you can say, well, I didn't have access to his portal. That's the justification when they find you non-compliant. You say, I don't have access to his portal because of confidentiality. I did the best efforts, which was to ask him for a screenshot. If he photoshopped it or faked it, that's beyond our control. Perfect. Any other questions online or? Nope. Great, perfect. So I'm going to pass this over to Darren and Sandy because they're going to take over.
Thanks, Sandra. I think your presentation is going to be 100 times more valuable and helpful than anything Darren and I have to say. So,
I doubt it.
well, thank you all for joining us today. We're the last one of the day. We saved the worst for last.
Best for last.
Welcome to Tales from the... Right. Welcome to Tales from the Trenches. My name is Sandy Chen, and with me is my colleague Darren Saul. We handle a lot of the employment litigation files in our group. And we basically wanted to just take the time and share some of our experiences and tips. I've been in the trenches for about 7 years. Darren, you've been in the trenches for a lot longer. You're
Just leave it at that.
A bit older, a bit more experienced. We've had some interesting experiences in some cases that have at least made me doubt my career choices, but we'll talk about those.
Very much so.
Our hope is that you can take away something and kind of be aware of the legal landmines when you're managing your employees, and get a sense of the issues that could arise during litigation. Litigation really does bring out kind of I guess it brings out the worst in people. Sometimes it brings out the best in people. But yeah, we're going to talk about real cases that either Darren and I have handled. Do you want to add anything?
Yeah, sorry, we're going to mess this up a few times. We're more of an interactive kind of presentation, and so when we're going through things, feel free to interrupt us, feel free to ask questions. Each of our cases we're going to talk about is kind of based on a specific topic. So if you've got something relevant, either past, present, or you're foreseeing something coming up, feel free to jump in. We are going to probably go into the question and answer portion a bit unless we get yelled at. And so you feel free to blend that in. Our advice is going to focus on practical solutions. And so, the disclaimer with this is your legal positions may be different than the advice we're going to talk about today. This is more a practically based approach where the legal positions that were relevant in each of the cases may not have been the ones that decided the day. Sometimes, as employers, you just pay a little bit of money or to get it gone. But this is more to talk about the risks and what that could do for you guys moving forward and how to mitigate those from the get-go.
So some of these cases are well, we're gonna change the names because, and Chris is gonna play the part of the employer. Sorry, Chris. I'm gonna be the bad employee, but
This is an accurate slide.
we considered a lot of people for this role, but I was the only one that made sense, you know. So okay, let's go to the first one. So tail number 1, the company cell phone. I had a case a few years ago involving some misconduct on a company cell phone. There were a group of it was 8 sales guys, right? And they had a company cell phone. They had a group WhatsApp message. This chat spanned years, so you can imagine what's on there. I had to read through all of it. You know, of course, you know, they were using the company cell phones to be this group WhatsApp message. So I guess we pretend I'm one of the sales guys in this group and Chris is our manager. You know, me and a few of the other guys in the chat, you know, we're bored, we're all kind of friends. We decide to start sharing some pornography, right? Actually, it was a lot of pornography, actually. Some of it was like humorous, some of it was a bit racist or sexist. Some of the porn got downloaded to our phones, accidentally, allegedly. But just in clear breach of the company policies, right? We're also talking about female colleagues inappropriately. We're disparaging Chris. We're talking about how badly the company, like some pretty bad stuff. So Chris finds out, he does a full investigation. He reviews the messages and he fires me for cause, right? Maybe rightfully so. I sue the company and, you know, of course, Chris is feeling pretty good about his case. This is all pretty bad stuff in the messages, right? And so where does it all go wrong for Chris? What was his mistake? And this goes back to a principle Jensen talked about earlier. But it turns out that Darren, who was also in the group chat, one of the sales guys, also did the same misconduct that I did. And we find out that he wasn't fired for cause, he just got a warning letter. And so I guess the next slide. And this actually happened, right? This helped the employee settle the case, despite the egregious misconduct that happened. And so, you know, you gotta apply, like Jensen said earlier, you gotta apply disciplinary measures consistently. And, you know, generally the same misconduct should receive the same discipline. I get that you might not want to do that in some situations, right? For business reasons, you like one guy more than the other, and that's fine. But you're just gonna have to be aware that, you know, all things being equal, that's gonna hurt you in litigation. Yeah, you can imagine the interesting experience we had at the DD examinations. It's me and the other lawyer and the court reporter, and we're just playing these videos, being like, "Did you send this? Why did you send this?" Let me get a copy of that transcript. Actually, I want to reread it. Okay. So I think we were gonna do 10 tails and 10 tips.
Yeah.
But we're gonna change that to maybe less than that. So secret recordings. Again, something Jensen talked about earlier. I'm just gonna do a real life case example. So Chris is the owner of a brewery, and he lays off most of his employees in response to COVID. You know, I was one of the few employees kept on, and but then I disclosed my medical condition to Chris, saying I need to be extra careful and vigilant at work because of the virus. And a few days later, after I disclosed this, Chris pulls me into his office and he tells me I'm laid off. And this is the quote he says. He says, "Your health, we're gonna have to lay you off." Little does he know, I record the conversation. And now I'm gonna file a complaint with the Human Rights Tribunal for discrimination on the basis of my very severe disability. Now, without this recording, it's gonna be a hard case for discrimination, right? The employee really has no evidence. And so, you know, maybe Chris was genuinely concerned about my health, but that quote doesn't sound good, right? It's the first thing in the recording. And he's handed me a pretty strong case, and, you know, he better pay up. I was looking at that case you brought up, Rowan. I think it's $200,000 that Chris is gonna have to pay me after a week of work, right? So I mean, I think most of you probably know this, but just assume the terminations meeting is being recorded, right? Because it's the employee knows, they know something's up. If you're pulling them to a meeting with HR or a manager they don't usually deal with, they're gonna know something's up, they're gonna pull their phone out. And I hear that even if it's in your pocket, it's still pretty good quality. I've never done it, I don't know, but it's what I hear. But yeah, I mean, generally, I think all the advise clients not to give a reason unless well, in certain contexts, if you're federally regulated, you might have to give a reason, but if you're provincial, you don't have to give a reason. Okay, I'll
One question.
Yes, sir.
Is it illegal to record someone?
No, it's not criminally, well, it's not a crime, but it's, yeah, as long as you're in the conversation. The case Jensen talked about was this employee where he made up like hundreds of recordings, in which case you probably have cause to terminate. But if you're just recording a termination meeting, courts aren't going to hold that against the employee.
But for any meeting such as an employer, if you disclose that this meeting is being recorded, it's totally fine. Like, you gain consent or you're informing the staff member that this is being recorded.
Yeah.
Instead of recording ways.
Yeah, so the question was if the employer discloses the recording, well, the meeting's being recorded, that's okay, and the answer is yes. Let's skip this one. This one's not that interesting.
Oh, this is good.
The returns, oh yes, the return to office manager. I don't know how many of you guys are still dealing with this remote work, calling your employees back. I see my hand up there. Anybody else? No, I mean, yeah, it kind of fell out of, well, it was really fashionable for a while, and then now it's not, and then now it's all of the hybrid, I don't know. So in this case, I think, it's one of those cases where, again, we'll use Chris as the bad guy, but, when COVID hits, I asked him if I can move to Ontario and work remotely from there. He says yes, right? We don't talk about the duration or how long we're going to be there. Chris has enough on his plate. He's a very busy manager. But he assumes I'll move back when the office reopens, right? And as the pandemic kind of drags on, it's been 3 years. There's been a few company-wide announcements that, remote work is going great for the company, and they won't be mandating a minimum number of days in office. So, fast forward 3 or 4 years, we're in 2024, 2025. The senior leadership at the company changes its mind on remote work. It's not fashionable anymore. They want to promote synergies and cross-functional collaboration. It's 4 years of business school. So anyways, Chris recalls me to the office in BC, and he says I have to be in the office 2 days a week. I say no way. BC is a terribly expensive place to live, so I'm not moving back. So anyway, there's been cases that's been litigated in this exact context. I wrote a blog about it actually on our web, which is somewhere on our website. But basically, there's two conflicting decisions, right? You've got one from Ontario, where this lady moves to Europe to work remotely. It's the Bird decision. I don't know if a few firms have blogs about it, but so when the employer tried to call her back to Ontario from Europe, the court said that was a constructive dismissal of her employment, right? Because the remote work from Europe had become a fundamental part of her employment now. And so there's another decision from our province, from the BC Court of Appeal. I think it's called Staley or Stanley, but that one went the opposite way, right? That one, the employee tried to move to Montreal and say that, I want to work remotely from Montreal. But when the employer recalled him and the employee said no, the court said that was cause for termination. So pretty different results. I think that the key distinguishing factor there was kind of the documentation that was in place, right? And communicating the right to recall. And so, in the case of me and Chris, he didn't say anything for years. right? But in the case of this other employee, where the employer was successful, they communicated within like a few weeks that, you know, you're gonna go, but we always have the right to recall you. And that was in writing. So yeah, I mean, I think the lesson is you just want to document changes to employee work conditions. I'm sure you all know that. And you have to set expectations around any privileges you afford them, right? You want to avoid, because sometimes they develop secret rights, right? They have these rights you don't know about, but it's if you afford them a privilege long enough and you don't set any conditions around that or expectations around that privilege, it's going to become a contractual right. Okay, I'll just do my last one maybe if we have time. Okay. Just cause. Sure, let's do this one. This one, okay, so this is actually my first, this one's about my first trial in BC. I don't need to use Chris, I'll just use real names maybe. But it was a cause case, and you know, Jensen went over how hard cause is, right? But you know, my clients, I was actually on for the employee for this one, and he had been terminated for just cause because he allegedly had some verbal altercations at work, and allegedly he was threatening to kill people and physically harm people at work. So pretty bad stuff if the employer could prove it. They didn't have any documentation to back up their allegation, and I think long story short, at the trial, the employer's strategy was basically call their entire workforce to the stand. And so there was at least 7 or 8 employees who came on, and they all said, well, you know, this guy is a bad guy. This guy's super violent at work. And then they all said how their boss was the greatest boss in the world, and how their workplace was the greatest workplace of all. Anyways, all their stories fall apart on cross-examination, right? They can't give any specifics. It's all hearsay, and they were all clearly biased. And I remember one of the questions I asked, I said, okay, so he threatened to kill you, right? And he was threatening to kill everybody in the workplace, right? And so did you call the police? Did anybody call the police? Anyway, so they didn't have any good answers. So we won, but I remember we actually tried to settle the case for less than what we actually got awarded trial. But I think the employer was just so confident that they had all these witnesses that were going to say the same thing that they didn't want to settle at all. So I guess the lesson here is if you, when you're looking at going to a trial or hearing, it's not a good idea to kind of try to hinge your case on the performance of your employees' testimonies. I mean, your employees are good at a lot of stuff, I'm sure, but you know, testifying under oath in a high pressure situation, you don't want to put them through that, or you don't want to paint your whole case on that. And again, I think proper documentation. I think the consistent theme today is proper documentation is very good, and not having it is very bad. Derek?
Thank you for that riveting take, Sandy. All right, so we've got limited time here, so I'm gonna cut some of these down. The first one I'm gonna talk about, and my pictures may not make a whole lot of sense, to be honest. I just searched stuff in Google and I put up whatever seemed to make sense. The first tale I'm gonna talk about is income structures. And so where you pay people with not only cash, but you also pay with shares, bonuses, kind of extraneous things like that, not just tied to salary performance or hours. Where you've got structures like this, a lot of people assume that when you terminate an employee, you only owe them their wages. Wages is defined very expansively, but where you have things like shares, for example, these are things I deal with quite regularly, is where you have shares and they're granted to people, restricted share units or options are granted to people as bonuses. Typically it's executives, but it can be people in management, supervisory positions. It's a good way to incentivize workers. It's a good way to incentivize people to act in the best interest of the company. And so it can be a very good tool in an employer's arsenal to make sure that you have a good, successful business moving forward. Now, where it falls apart is where you terminate someone, and all of a sudden you've granted them these interests and equities in your company, maybe over a period of years. And when you terminate them, you don't want to pay these out. Unfortunately, unless you have very, very clear language in your employment contracts or in the grant documents, you may owe them this. If they've already been granted this prior to their termination, you may owe them this over their notice period. You may owe them this irrespective of their notice period. And so one case I dealt with, about this is, the clause in the grant documents and in the employment contracts simply said they had to be actively employed to receive the grants. Now, the grants were worth in excess of $300,000 at the end of the day. The employer terminated this person. They were a VP in a department, and their notice period was over 20 months. That ended up, the entire grants were worth about $700,000, but that employer had to pay out over $300,000 upon terminating that person, simply because they didn't have very simple language in their agreements, which is you want to have a forfeiture clause typically to say that upon termination you're forfeiting, bonuses, you're forfeiting grants, you're forfeiting these rights, and so you want to check over your agreements, make sure that you guys have those. We can obviously help with that, but the practical realities are when you have these kind of, and I've seen this a lot more recently with the hybrid environments and things like that, is people are getting into more creative income structures, which is great because people are loving it, but there's also a lot of issues that come along with it. So I think just be aware of that. Let me see. Any questions? No? All right. So we've talked a bit about the bullying and harassment, so we may skip Sandy bullying everyone. I think the only thing I want to say about this one is the investigation. So be very, very careful when you're doing this. Jensen mentioned this, and I'm pretty sure I think Fiona guys mentioned this too. You want to make sure that you're doing things in the correct order. Don't just talk to the complainants and then make a decision. Please don't talk to the respondent only and then make a decision, because I've seen that where you say, well, we went to the person who's accused of all this. They said X, Y, and Z, and we're fine with it. Make sure you talk to the complainants. Make sure you talk to the respondent. Make sure you talk to the witnesses. Make sure you do this in a timely manner. And if you do it all in one day, I think take a little time to consider before you make a move, because I've been on the employee side where everything's done in one day and a decision's made before 4 o'clock that day, and that's very easy to assault. From an employee perspective, I see some people nodding, so hopefully you're on the right side of that, and I haven't stepped in it. Okay. Yeah.
Is there any order that we should follow, like the complainant and the respondent and the witness, or?
So I think it's open to, depending on the situation. I mean, my preference is typically to do the complainants first, then witnesses, and then go to the respondent with everything at once. And then you can go back to the complainants after to address anything that's raised, but then the respondent's getting the full case against them. It's much more fair. I think that's generally the preference.
So Darren, I sometimes have waited to go to witnesses because if the respondent agrees, that happened. This is my perspective on what happened. You actually don't need to go to a witness. So it's very case specific.
Yeah.
But there's investigators that will do exactly what Darren just said, and then there's others that will do it where it's complainant, respondent, witnesses.
Yeah.
So it's very fact specific, like you've heard us say quite a bit.
Kind of assess your business and all aspects of your business. I know there are people working in various areas, and I know some of you are maybe CLC regulated by the Canada Labour Code, federally regulated. Some of you may be provincially regulated. But something that employers, sometimes don't always know is different parts of your business can be regulated by different entities. So you can be provincially regulated for 90% of your business and have 10% of it regulated by the Canada Labour Code. And this is important in the case of where you have termination clauses. You may have a fully enforceable termination clause under provincial regulations, under provincial standards, in any of the jurisdictions you work in. But you may have a subset of your group that is federally regulated. That may render your termination clause ineffective. So look at all aspects of your business. Where this typically comes up is telecommunications. You see people who have, they, for example, do sales in BC and they sell internet service providings or alarm systems or whatnot. But then you have, installers. Now, installers have been found in the past to be federally regulated, even though the business itself is provincially regulated because they're dealing with the telecommunications software. You may have companies that, for example, I had a case where there was a sale going on of it's an electronics company. They were being sold to another entity, and the individuals who were being sold, they terminated some of the higher level VP people, and they were doing sales of certain type of technology across Canada. Now, there were enforceable provincial clauses in all their contracts. However, because they were dealing with a certain type of telecommunications technology, the people who were specifically dealing with that, the sales of that and the use and installation of that were federally regulated. And because of that error, the company ended up paying out, and this kind of goes back to the shares. The share grants that these vice presidents and directors had did not have forfeiture clauses in them. So when they were terminated, we essentially went after them, and the payouts were in the 7 figures for these companies. And so it's something, and when you look at it on its face, the clauses were all enforceable. Now, it hasn't gone to a trial. There are a number of trials which do say that different parts of the businesses can be regulated differently. So you may not realize that when looking at your business. So when you're opening a new division, when you're expanding, even for existing divisions you have, take a look and see, ask yourself that question, do I have that exposure? Because it can be very important. I think we're going to Q&As now.
Yeah.
All right.
Yeah.
Any Q&As?
Pull this back up on here.
Does anybody have any questions, just for general? Anything there?
Yeah.
Yep, you have a question? Great.
Sure. So from a just cause standpoint, what about like time theft or work avoidance? You have all this work from home kind of environment. How does that impact the just cause?
So the question is for just cause, everything's like time theft and work avoidance kind of, I guess, factor into terminating for just cause. A lot of the times it's going to depend on what evidence you have. I think in terms of how are you monitoring this, how are you establishing it, one of the big things is have policies in place. If you have people work from home and you're concerned about time theft and things like that, have policies in place, how long you need to work, whether or not it's piece-based work. You have established work hours. Maybe you have tracking software on the computer. The biggest one is proof. With a lot of these, it's I've seen people come to me and say like, well, we think they're stealing time. We don't have any records because they are working at home. It's easier when they're working in the office. You can see when they clock in, clock out. You can track them when they're working there, but at home it's a lot more difficult. There's what is it? I saw a friend of mine who will remain nameless. No one here. It's definitely not Sandy. Uses like mouse movers, which is an app you can get that moves your mouse so people can track it, which is crazy. But those exist. So fun tip. Definitely not Sandy. Chris, definitely not Sandy. And so one of the keys is gather evidence. As the employer, gather evidence. Feel free to chat with one of us, but gather evidence, talk to the employee. I think the biggest mistake a lot of employers make is they gather the evidence, then they just terminate. Usually you want to give them the chance to explain any of the evidence for multiple reasons. One, you've then got it in writing, and if the explanation is terrible, which a lot of the times it is, you've then got that set in writing and you can make an informed decision on that basis. But you've also given them the chance to explain that away. There may be an explanation for whatever you're seeing, right? You never know. And so just get that information up front before embarking on a course of action. But yeah, time theft can typically, that can ground to just cause termination.
Yeah. Also, surveillance being introduced into the workplace is permitted with some exceptions. There's some advice from the Office of the Information and Privacy Commissioner of BC that you should be aware of. So don't just.
So just as an addition to what Darren was saying, you can introduce surveillance into your workplace carefully. You must abide by some guidance that has come from the Office of the Information and Privacy Commissioner. there are privacy concerns when you start putting in surveillance. So if you are thinking of tracking machines or tracking software or other ways of kind of tracking what your employees are doing, whether in office or work from home, please consult us so we can help provide some advice on that privacy side of things.
Don't put cameras above people's desks.
Yeah.
I've seen that, so don't do that one.
Yeah, and just to add on to that, especially for if some of you have like Ontario-based operations, there's actually a strict requirement in Ontario that you need to disclose that you have any sort of electronic monitoring software above a certain threshold for a number of employees. So low requirements of that can end up tripping you up. And the other thing to note is that I tell virtually all my clients, do not record audio. Even if you're going to record things like keystrokes or video, don't record audio because you could accidentally walk yourself into a wiretapping issue, which is a criminal offense.
Yes, in the back there.
What about dash cams in vehicles?
Okay. The question was about, what about dash cams in vehicles?
Yes, thank you.
Yeah, so the easy response to that is yes, but you need to have proper policies in place for that. Basically, the thing is, especially when you're dealing with any sort of monitoring on on company property, whether it be a vehicle or a computer, generally speaking, the answer is yes, you can monitor, but the employee needs to be informed that that is happening in most cases. Fiona might have more to add.
Yeah, I was just gonna add, like, don't just willy-nilly add it because you think it might be helpful, like actually go through what am I trying to deal with? What is my concern? Is this actually gonna help with the concern? Because the Office of the Information Privacy Commissioner will look at the thing that's the least intrusive to deal with the problem you might be addressing. So there's a case from, I wanna say 7 or 8 years ago, there was concern about theft around the office, so cameras were put in. The cameras were put in the lunchroom, even though there's no concerns about theft in the lunchroom. So, to have a proportionate response to what is truly a concern. And also, if I remember correctly, it's well since I've read that case, that wasn't actually a concern. It was kind of like a bit of a, maybe it'll happen, but there hadn't actually been a pattern of theft beforehand. So when you're thinking of bringing in any sort of surveillance, what's the need you're trying to address, or what is the concern you have? Is there another less intrusive way of addressing that concern? And the notification piece that Jensen mentioned is very key. Employees need to know that they're on camera, potentially. So there's a bunch of rules under the Privacy Act that we need to follow.
Yeah, with dash cams, it can be, there's different types of dash cams. Like there's forward-facing ones, and there's the ones that can look at the driver too. So I think Ron and I did a pretty extensive policy for a federally regulated employer that wanted some ability to look at the driver in certain situations. So some of the programs, the software is really complex. Like it'll only trigger when there is an event, like a speeding event or a sudden break or something. So there's a legitimate safety reason why you'd want to have that information of the person, the driver's face. But it has to be, as Fiona said, you can't be constantly recording them. It needs to be, rationally connected to a legitimate work purpose.
So Chris, to that point, if we have GPS tracking software in our vehicles, but it doesn't record their face, do we still have to have them sign off on a policy to tell them we do that?
I would say yes, it's still a form of surveillance and tracking.
And there was a case about GPS from the Office of Information.
Yeah, so I think best.
7 or 8 ago. I just don't have it published.
Yeah, best practices wise, you want to let them know they're being tracked, and you have some trouble if you try to rely on that information for discipline. There may be an objection there to say we're not going to admit this because it's breach of privacy, or an employee might find out about it, complain to the privacy commissioner, and then might investigate and make some orders and have to change the practice.
So I had one that was like that, where there was a company vehicle that had GPS tracking in, and the person wasn't notified, but they were allowed to use the company vehicle for private use as well. And so that's really where they ran into issues.
is where they were allowed to do private tasks with the company vehicle, but the GPS wasn't turned on specifically to when they were working, it was just on. So you could run into issues there. So like Chris said, best practices is probably just have a policy dealing with it, so that the employee knows. You also then reduce your chances of them actually, messing around in the vehicle and causing issues for the business. And the only thing I may add to the audio recording thing, because I know there's been some talk about being able to record and then making sure you're not recording other things, is the rationale behind audio recording is you can't record a conversation you're not a part of. And so that's the key, is if you're part of the conversation, you can record it, the other party doesn't need to know. But if I'm recording the conversation in a room where it's Sandy and Chris talking, and I'm not in there, I'm not a party to that conversation, that's where you get into the illegality. So just, if you're part of the conversation, it's okay.